that the matters are disposed of on an early date. This litigant is before the court for the last 12 years. Let it remain, matter be called up. We'll see after that.
Listing for matter for tomorrow, Your Lordship.
Why?
APSC matter, Your Lordship.
Huh?
APSC matter, Your Lordship.
APSC, what happened APSC?
Your Lordship, discharge from the APSC.
Fresh matter?
Fresh matter, Your Lordship.
Fresh matter.
Matter.
All right.
Malak, for listing of an arbitration petition, Malak, next Monday, Malak.
Next Monday. All right.
Much obliged.
Please, Your Lordship. Lordship, for listing of, for correction of order, Your Lordship, there is 4 petitioner, Lordship. Similar matter and similar mistake was found in the order, Lordship. Can you tomorrow or
Tomorrow, all right, tomorrow.
tomorrow? Oblige, Your Lordship.
Or let it be day after,
Day after.
Thursday.
Okay, Your Lordship. Oblige.
Daily list for admission item 1.
I am bound by my own judgments.
His Lordship, I have gone through the judgment, and some points are there which are not similar with our present case, Lordship.
Judgment to go to. See. Do you have an extra copy of that?
I have my copy on.
All right, then take it out. Yes, tell us.
Lordship, facts are not same. In that case, Lordship, he was first reinstated again as per order of the Honorable Court. Then again the proceedings were here, Lordship. But in our case, it's a fresh case. He was during service. The raiding entries were there. Secondly, Lordship had dealt with that incorrigible offender, and we have stated in our affidavit at paragraph 4E that although there was may I read my affidavit, Lordship? 4E of my affidavit, page 47. That the term undesirable or incorrigible offender has not been defined anywhere. However, an individual is said to be an incorrigible offender when he commits offenses at regular interval.
No. What I'm trying to, I do not know whether it is come out or not. You see, there are 4 episodes which resulted in raiding entries.
Lordship.
In each of these 4 episodes, there was a proceeding, there was some punishment, censure, warning, whatever was there. So these episodes are now closed in a sense that each of these episodes, you have proceeded against him.
Lordship.
Some punishment was imposed, and because of which it resulted in a raiding entry. Now, in terms of 108, is it sufficient to say that no, these are 4 raiding entries and therefore he is automatically out? Now, that has been clarified by number of judgments that automatic dismissal or removal is not there. So there has to be a conscious decision by the authority to say that in spite of all these, sufficient opportunities were granted to him. He was found to be incorrigible. He maintained the same indiscipline, etc. Or he's become a deadwood and therefore he is required to be removed. That finding perhaps is required in terms of 108.
Lordship, that has been done at Lordship may find at I have flag mark page number 203. 203.
203.
108 and provided certain guidelines that how before that it is not an automatic one, but you have to re-examine those cases. So And more so, Lordship, here another difference is that he had not attained the 18 years, which is as per rule 108. If he had attained 18 years, he has to take up to 20 years so that he is eligible
How
for.
many years has it?
He, at the time of issuance of this impugn order, he has 15 years, 7 months, 21 days. So that is followed in all the Supreme Court cases also. Lordship, 203. And more so, Lordship, out of this raiding entries, etc., he pleaded guilty. I have annexed at page 88 and 91. In 2 occasions, he pleaded guilty also. Page 203, that 202, 203, etc. are etc. from our record. That page 203 is recommendation of the Commandant 41 Assam Rifle on the case of 4 raiding entries in respect of so and so. Then, Lordship, he submitted his reply, and after receipt of his so-called reply, Lordship, page 203, paragraph 2, Lordship, the competent authority has perused the reply to the so-called notice by so-and-so. The individual in para 4 of the reply to so-called notice has alleged an offer of malpractice and subsequent personal vendetta to punish the individual. In para 5 of the reply to so-called notice, individual is also alleging the CO is punishing him without sufficient cause. In order to process the discharge of individual on account of 4 raiding entries, the reply from unit on the allegation made by so-and-so is a mandatory requirement. You are requested to forward the reply by so-and-so. So we have asked for the decision of the unit, Lordship, which is as per 108, that unit commandant before issuance, unit commandant's recommendation is required, Lordship. Then, Lordship, 204, comments against reply of so-called notice submitted by so-and-so. We have received the reply by the commandant, and after all going through all these only, Lordship, the decision of the authorities at page 206.
So you see, come to page 205. That is the final conclusion.
Lordship, the individual has been a perpetual defaulter, which is evident by the punishment awarded to him by 3 different commandants spanning a tenure of 6 years.
That is what we're saying. That is already closed chapter. Now, in spite of that, what is your assessment in respect of the individual?
Because
this is subject to correction. This is the understanding of the court, that whatever you have imposed for whatever reason, and since no appeal has been filed, they have attained finality. Now, can you use those grounds or those punishments imposed as a ground while examining 108, or something more is required?
Lordship, because 108 is clear that if he requests 3 raiding entries, then we have to give him a so-called
that is already settled by the judgments.
Lordship.
That 4 raiding entries does not mean automatic dismissal or discharge. You have to take a call whether it is necessary to retain him. One of the grounds is 18 years.
Lordship.
And if it is not 18 years, then whether it would be effective to retain him or simply let him go. That finding has to be there. That finding prima facie perhaps is not there.
Lordship, because 108 says that if only 108, Lordship, before taking the final decision to order the discharge, the punishment concerned shall be informed through a so-called notice that his retention in the service is considered undesirable for having incurred 4 or more raiding entries, thereby also calling upon him to show cause as to why he should not be discharged from the service for being considered unsuitable for the service in the Assam Rifle. The individual shall be given minimum 15 days after receipt of so-called notice to submit his reply. After receipt of the individual reply, if any, the case shall be put up to the authority competent to sanction the discharge along with recommendation of the commandant of the unit concerned. We have done that. Before passing the discharge order, authority competent to sanction the discharge under this para may seek the advice of the law officer concerned. His only may, Lordship, from the legal officer.
What happened on the 4th raiding entry? fourth reading entry.
Lordship, after 3, we have given him an
Warning.
yes, warning letter. Then he committed the other 2 offenses. Page 99 is the 4th offense. That proceedings are there. And
No, I'm talking about the 5th offense, which is the fourth reading entry.
yes, page 99 and 101. And all opportunities were given to him to examine the defense witnesses, which he declined. And he had pleaded guilty of 2 offenses.
What is the conclusion of the authority on the 5th offense? Findings?
Two offenses he pleaded guilty. So, but other 3, Lordship, Lordship adds 204, clause C.
04.
On 8 March 24, the individual being fully aware that he had incurred 3 raiding entries and could be dismissed from service on award of 4th raiding entry, incorrigibly.
What punishment was imposed?
4th raiding entries, Lordship. 14 days.
Where is it?
14 days, page 45.
45.
45 is my petition, and also Lordship fine at so cause notice at page 73. D. Fine for 14, that is black ink, and then the last one is again the red ink. Fine for 14-day pay in any 1 month by so and so 41 Assam Rifles on 13th.
Yes.
So 108 is mostly on that you have to give a so cause notice, and he, after giving so cause reply also, we have considered his case. He pleaded guilty in 2 cases. Subsequently, and he had also not completed the required mandatory period of 18 years. And he will be eligible for pension as per CCS pension rules. That also we have stated in our affidavit, because he has completed more than 10 years.
Yes, what do you say?
My lord, regarding WBC 212/2022, my lord,
How many cases are there?
here, my lord, my lord own judgment. Here, my lord, whether it is similar with me, my lord, I have gone through, my lord, in para 5, my lord own judgment.
You're referring to which matter?
Lordship judgment.
212.
53? There is WPC 53?
212/22, Lordship judgment.
Okay. Okay, 212, yes.
My lord, here, my lord, in para 5, my lord, it is stated that, my lord, I'm not reading the whole para, my lord. Only this, my lord, there was no independent witnesses examined in support of the allegation that he was found intoxicated. This was happened with me also, my lord. Same. Then, my lord, in para 7 of this judgment, my lord, 107 Regulation 2016, before recommending discharge, an impartial inquiry has not been made out, my lord, in my case. in their discharge order, they are saying that first para, my lord, I am incorrigible offender. And my lord, incorrigible offender is, my lord, in the 107. They have skipped 107 and directly come to 108, my lord. So both 107 and 108, they have.
Some rifles.
Yes, my lord.
Some rifles.
Then, my lord, before passing discharge,
File binding opening.
my lord, before passing discharge, my lord, the authority will reconsider the case in the light of the individual reply to the show cause. But in this case, my lord, they have not considered. They have said your reply is found unsatisfactory. But why it is unsatisfactory, they have not stated anything, my lord. First of all, my lord, incorrigible offender regarding it is stated in 107. In their discharge order also, it is, they are saying that I am incorrigible. But in their, my lord, they have not rely upon on 107. Before 108, they have to rely upon 108, my lord, where when impartial inquiry is necessary, my lord. Not mainly, then, my lord, 108, what says, my lord? 108B says, each case of the individual having earned 4 or more rating entries shall be examined on its own merit, depending upon the nature and gravity of offenses and the aggravating circumstances. But in the petitioner case, it was not done. First rating entry was given because, my lord, his daughter was ill, my lord. He was not given, my lord, leave. That's why there is a delay, my lord. But there is sufficient cause. But punishment is given when there is no sufficient cause. In my case, it was a cause. And then others, my lord, they have intoxicated me without any, my lord, examining any independent witness, without any medical authority.
These are closed.
Yes, my lord. That's why
you did not go in appeal against them.
After
you did not challenge it.
Yes, my lord.
You have
That's why I am saying,
you have
my lord.
accepted these rating entries.
Yes, my lord. But
Then-
they have not, my lord. But they have not, again, my lord, as per Honorable Supreme Court, as per 108B, my lord, they have not, my lord, given me that opportunity, my lord, directly.
What opportunity?
My lord, they have not, my lord.
You submitted a reply. They have issued a show cause. You submitted a reply. You have accepted.
Yes, my accepted, my lord, only 2 occasions. That was also, there was also, my lord, a reason behind it, my lord. They forced me to sign on. You write that gone, my lord. But I am just saying, my lord. However, because of my health condition of my wife was very serious, that's why I have signed that and I have gone to house, my lord. First of all, my lord, I have completed 17 years of service continuously from 2008 to till today, my lord, and without any difficulty, my lord. Let me complete, my lord, another 2 or 3 years so that I can get pension, because I have spent, my lord, a reasonable period of my life, my lord. They are the model employer, my lord. They have also seen some sufferings and problems. They have to see, my lord. I have given a reasonable period of time of my life. And, my lord, in my reply also, I have said, my lord, that in near future, if not admitting, if I am, my lord, committing, I will not commit anything, my lord. Let me complete 20 years so that I can get pension, because I have children, I have parents, my lord. I am the only breadwinner of the family.
What is the qualifying period?
20 years, my lord. From December 2008, my lord, I am continuing till today, my lord. And, my lord, one thing, my lord, in my reply to their additional affidavit, my lord, I have annexed many documents, my lord, where some 9 rating entries are also continuing. 8, 9, 10, my lord, there is no such distinct rule that as soon as I am getting 4, I will be discharged at any cost, my lord. I have given many documents, my lord. Well, they have to see my condition, my lord, problems, my aggravated condition, my situation, and the reasonable period. As per Supreme Court also, if I am, my lord, a pensionable period is also coming, my lord, I may be allowed to continue. And I am in no break in service, my lord. December, I am completing 17 years, my lord. That is my case, my lord. And, my lord, they have taken it, my lord, personally, my lord. That I am not going, my lord. But as per Supreme Court decision, Amarendra Kumar Pandey's husband, they have to eat. If I get 4 rating, it is not automatic, my lord. They have to see my conditions, aggravated conditions, in which situation these offenses were done, my lord. And I am saying that, my lord, my daughter was ill, my wife was ill, my lord. That's why my lord, something happened. But I am continuing, my lord, without any difficulty. I am getting salary, my lord. 17 years I am completing, my lord. If I completing 17 years, my lord, I may be allowed to get the pension, my lord. That is my case, my lord. And in this, my lord, 2022, my lord, My lord, it is similar with me, my lord. I have, my lord, gone through, my lord. Moreover, I am a rifleman, my lord. I may not be so educated, my lord. I may not be my lord, aware of all the consequences, my lord.
No, all these have been dealt with earlier.
And already I am punished, my lord. For that, my lord, I am punished. I am accepted, my lord. But let me continue, my lord. If, my lord, without any inquiry, my lord, these punishments are given, my lord, that is wrong. Then why they have passed their advisory? Why they have passed their regulation?
What is the advisory? What is the advisory?
Advisory, my lord, in my writ petition, kindly see. Advisory, my lord, after Virendra Kumar Dube's husband, my lord, they have passed this annexer 6, page 30, my lord. 30 of my writ petition, 38, my lord. Here also they have saying the same thing. They have to see the condition, they have to see the, my lord, situation.
Page number?
Annexer 6, page 38.
38.
Discharge from service for incurring 4 reading entries. Here also, my lord, same thing they have stated, whatever stated in Amarendra Kumar and Virendra Dubey, my lord. After Virendra Kumar Dubey, my lord, this advisory they have passed. Here, my lord, total service rendered by the individual should be considered. Here, not written that it is 18 years, 17 years. Total period, I have completed maximum period, my lord, up to the, my lord, pensionable period. There is nothing on record to suggest that competent authority had taken into consideration the long service rendered by the appellant, the difficult living condition, and the harsh station at which he had served. There is nothing on record, my lord.
What is this advisory? Yes. What is the qualifying service for pension?
20 years, my lord.
20.
In 10 years also he
No, my
receives
lord, they minimum person, my lord. If he complete 20 years, then he will get pension.
pension as per CCS rules is there in completion of 10 years also. He is eligible for that, but the regular pension that is for 20 years, and all the judgment says that
He is put in 15 years.
15 years, 7 months, 21 days, that date of impugn order.
By now, my lord, almost 17 years, my lord. Because there is no break in service, my lord.
That 18 years is a specific one, and lordship those he had never challenged, and
My lord, regulation does not say it is a reasonable period, my lord, maximum period. If the
All right, heard counsel for the parties reserved.
advisory.
the lordship may I submit other some judgments on the point that
Prepare a list and give it to us. Only and indicate the what paragraphs,
lordship.
what purpose you're relying it on.
Right.
For both the councils if you want to. Yes.
Otherwise, it's heavy lordship.
Yes.
Item 2.
Lordship,
kindly taken up this matter along with item number 16. My senior is on next.
Item number
16.
16. Oh, that series, it's part of the series. Yes, madam.
Yes, ma'am.
We'll call it up then together.
Item 3.
Please, your lordship, this is an application under section 11, lordship, for appointment of arbitrator. Lordship, the facts,
Jurisdiction.
lordship, jurisdiction, my lord. Also, in that regard, lordship, first, the lordship, I'd like to submit.
There are judgments of the apex court to that
Lordship,
effect. Are you aware of that?
lordship, here, lordship, we are, one thing, lordship, is that we are a stage prior to that, lordship, because, lordship, the seat was not fixed, lordship, in the agreement, only the venue was fixed.
Where is that?
Lordship,
No, the venue is in Delhi, I think. Where is that?
venue is Noida, my lord.
Noida, then.
But lordship, our argument here is that lordship, since this honorable court has referred the matter for arbitration, lordship, the arbitrarity of this issue was decided by this honorable court. Lordship, this honorable court has the jurisdiction, lordship. They ought to have raised the issue of jurisdiction in that on stage, lordship. By not, lordship, opposing the jurisdiction in the writ petition, lordship, they have already.
Why did you approach this court?
Lordship, this court, lordship, is that lordship, 10% of liquidated damages were retained by the authorities, lordship, because of delay. Lordship, thereafter, lordship, the director, who is also the engineer in charge, lordship, had recommended the waiver of the 10% deduction, which lordship, thereafter the authorities did not take up after that. Lordship, we approached this honorable court so that, lordship, the recommendation which had already been sent by the director, lordship, that may be acted upon, and lordship, the 10% which was retained may be given back to us. In the meantime, lordship, during the pendency of the writ petition, my lordship, the authorities came up with an affidavit where they say that is after this writ petition was filed, they took a decision that, lordship, the recommendation was done away with, that was not accepted, and they rejected our prayer for returning the 10% of liquidated damages, lordship. And lordship, in that proceeding, lordship, the authority, lordship, they said that this writ petition is not maintainable in the sense that there is an arbitration clause. Lordship, our argument was that since arbitration clause excludes, lordship, such situations wherein a final outcome has already been decided, therefore there is no, therefore, lordship, the recourse to arbitration may not be done in terms of general section clause 21.1. But lordship, the honorable single judge, lordship, if I may take your lordship to page number 26 of this petition, lordship, honorable single judge had clarified that had referred the petition for arbitration with along with a clarification that the conclusion so arrived is based upon the reasons that the determination required to be made would entail adjudication of disputed questions of facts and law, and further the materials before this court would not be sufficient to adjudicate such questions. Therefore, lordship, the matter was referred for arbitration, not because of a clause of the arbitration. By this clarification, lordship, the agreement was already done away with, lordship. It's a court referred arbitration, my lord, not arbitration in terms of the agreement which was in existence, my lord. And also, lordship, in page 27, lordship, the court also made it clear that the parties before this court may either agree upon an arbitrator and refer their disputes to him, or failing the agreement would be liberty to take recourse to the provision of Arbitration Conciliation Act, lordship. Therefore, we are before this honorable court. Lordship, the referral court is just this honorable high court, my lord. Therefore, lordship, the question of jurisdiction does not arise at all, lordship. And this is a case, lordship, where the seat was not agreed upon, lordship.
Where is the agreement?
Lordship,
Where is the
agreement, lordship, it's, lordship, it has been annexed by the authorities, lordship, in their affidavit, lordship. At page 16,
60.
my lord.
This is only the relevant part.
Yes, my lord. The agreement is quite bulky, so,
How have you enclosed the part of the agreement?
well, if your lordship desires, my lord, I can produce that.
No, it's not a question of desire.
But
The,
it is the relevant part only which, my lord, took into account
you have to file it in a separate, file it as a separate paper book if you want. And you can refer the clauses, but this becomes incomplete.
in the, I'll do that. I'll do that. But
Where is the seat?
Well, lord, seat is at
T1.
Noida.
Hmm.
After,
Venue of arbitration.
yes, proceedings shall be at Noida.
Lordship, this is
It
clear,
is
Lordship.
further clarified that both the parties to this agreement hereby undertake not to have recourse to civil court to solve any of their disputes whatsoever arising out of this agreement, except through arbitration.
You did not raise these objections in. Was there any objection in terms of the jurisdiction before this court earlier?
No, this is for the first time that they are asking for arbitration in 11.6. Well, when the writ petition was filed, Miller, the basic argument that was made was that because of the existence of the arbitration clause, writ petition was not to be maintainable. That was taken at the earliest point of time, way back in the year 2014. But they pursued with the writ proceeding, Miller, and ultimately the Honorable Court held that the writ will not be maintainable because of the arbitration clause, and left it open for the parties to take recourse to the Arbitration Act. Now, if the recourse is taken, Miller, 11.6 application is filed, there are two things that are required to be gone into at the very initial stage is whether it is the venue or the limitation. We have also taken a ground on limitation. By the time they have filed this application, it is more than 17 years old. The cause of action had arisen by, even if it is stretched from time to time, Miller, the last cause of action was in the year 2014. And the initial cause of action was in the year 2000.
This can also be decided by the tribunal itself.
Limitation, yes. Limitation point, yes.
Decided by the tribunal.
It can be decided by the tribunal, but then, Miller, there are also judgments which say that if it is apparent on the face of record that the question of the claim is barred by limitation, Miller, then the arbitral court can itself go into that aspect of the matter and decide whether
you filed that agreement before the court. Or who has it? You have it.
Lordship, we also have a copy.
So you file it.
Lordship.
You are asking for. This is an application filed by you.
Lordship.
To file the arbitration agreement.
Otherwise, this was, Lordship, only in reference to the Honorable Single Court Judge. Therefore, we had not filed the agreement, Lordship, because Single Judge had already given us a liberty, Lordship, to approach this Honorable Court.
No, but then the Single Judge did not dwell into the aspect of limitation, seat of arbitration, etc.
Limitation, Lordship, the thing is that, Lordship, the case was already pending before this Honorable Single Judge. Lordship, Single Judge had disposed of the matter. Therefore, Lordship, thereafter we approached the division bench, Lordship. Division bench, Lordship, affirmed the order of the Single Judge. Thereafter, immediately we took steps for arbitration, my lord. Therefore, the question of limitation does not arise at all, Lordship. The division bench has condoned that period. And since the matter was pending before the Single Judge, Lordship, the arbitrability of the matter was under consideration. How can we, Lordship, initiate arbitral proceedings, Lordship? Therefore, there is no question of limitation in this matter, my lord.
This was rejected. Your objection was rejected.
No.
Page 34, para 8.
Page 34.
Appeal was filed by you.
Appeal was filed by them.
We had
By
filed
them. Okay.
And in the appeal also, Miller, writ appeal also, Miller, there was a delay. However, that was condoned. The delay in filing writ appeal was condoned, and ultimately the order of the Single Judge was upheld.
Why did you go in appeal?
Lordship, because, Lordship, as per clause 21.1, arbitration, Lordship, the arbitration clause excludes a situation wherein a final outcome had already been taken place. Lordship, in this case, Lordship, the rejection had already taken place, which is a final outcome, my lord. Nothing has to be done beyond that. Therefore, Lordship, we say that it's outside the jurisdiction of the arbitration clause. However, Lordship, the division bench affirmed the decision of the Single Judge. But, Lordship, here I'd like to take your Lordship to the fact that Single Judge has made the clarification that since this issue, Lordship, entails questions of facts and and records will also have to be seen, Lordship. Therefore, the court had, Lordship, referred the matter for arbitration, Lordship, not in terms of the arbitration clause, Lordship, which is at, Lordship, page 26, my Lord. Page 26, which is part of paragraph 18 of the order of the learned single judge, my Lord. The last portion, Lordship, it says, the conclusion so arrived at is based upon the reasons that the determination required to be made would entail adjudication of disputed questions of facts and law. And further, the materials before this court would not be sufficient to adjudicate such questions. There's a clarification.
So
my
there
Lord.
was a finding by the coordinate bench that it should be referred for arbitration.
Yes.
There was no objection on your
No,
part
Milord,
that arbitration cannot be
No,
resolved.
Milord, if you're, Milord, this has to be, in my respectful submission, Milord, this has to be read with the final paragraph that is at page 21, page 28. Before parting with the records,
28.
page 28, yes. Before parting with the records, this court finds it relevant to observe that the observations made herein shall not affect the claims and counterclaims of the parties if they resort to arbitration for resolving the dispute involved. Now, the observation is that the dispute that is sought to be raised in the writ petition requires a decision in an arbitration proceeding. Now, that by itself will not be a factor to decide whether or not the arbitration application is maintainable.
Even that is to suggest that the court at the time of disposing of the matter was consciously not aware whether these matters can at all be referred to arbitration. The finding conclusion of the single judge,
Yes,
and which is upheld by the division bench, is that been referred to arbitration.
No, Milord, if
there is no objection on your part to say that it can be referred to arbitration.
Milord, I can take the objection only when, my Lord, the application for appointment of arbitrator is made. Because the question of venue or seat of arbitration, as I have been telling.
Question of venue is a different issue. Question of venue, of course, once the application is filed, you can raise your objection. But on the question of delay, latches or limitation, when the single judge has referred both parties,
No, my Lord,
relegated the parties to arbitration.
My Lord,
and it was an inter-party order.
My Lord, that observation also, my Lord, in my respectful submission, cannot be a substitute to 11.6. Because if that is to be if that observation is to be understood as a direct reference to arbitrator, then there would be no necessity of filing an application under 11.6.
No. 11.6 is to see whether the parties have completed their responsibilities while appointment of arbitrator or not, primarily. A delay and seat and etc., these are ancillary issues, can be looked into. Essentially, court has to see whether there is an agreement for arbitration.
Yes.
And the parties have agreed to go into arbitration. Now, there is no dispute that you have an arbitration agreement.
No. In fact, my Lord, that was a plea taken by us that it's an arbitration agreement, so the remedy lies before arbitration.
Therefore, when you know that according to you that there is a delay or is barred by limitation, why was this plea taken before the court? That the matter can be resolved by arbitration.
No, our plea was that writ petition was not maintainable because of the arbitration clause.
Exactly.
And my Lord, that plea was taken long time back.
Litigant can't be remediless.
My Lord,
either you say that yes, arbitration is maintainable, it has to go for arbitration. My Lord, that will not be accepted to mean that it will go to arbitration subject to delay and etc.
My Lord, your Lordship will also kindly consider this aspect. This objection was taken way back in the year 2014. They remained silent on this. If they had slept over their rights for 11 years to get the writ petition disposed of on the terms that writ petition is not maintainable, my Lord. Well, it's an act of their lackadaisical approach.
No.
We took the objection in the year 2014 and they did not pursue it. And they did not pursue it.
What? But there is no record in the learned single judge's order that you had raised an objection that arbitration at this stage is not maintainable because of the limitation. Or the question of limitation we left open to be decided.
My Lord, the question of limitation can also be addressed by the arbitral tribunal, my Lord. As a matter, my Lord, as a matter of
what appears to us is that the conclusion of the single judge, subsequently upheld by the division bench, is that parties are to be relegated to arbitration.
No, here, my lord,
will it not be a?
it is the opinion of the court that in the interest of justice should be made if the parties are referred to under section
Arbitration.
8 of the Arbitration and Conciliation Act.
Correct. Now, will it not be a travesty of justice to say that it's in the interest of the court that this writ petition has to be closed, go for arbitration? But when you go for arbitration, you can't do arbitration because it's barred by limitation.
My lord, even if I give up the plea on limitation, my lord, still the question of venue will be there.
That will decide.
Still the question of venue will be decided.
We are saying that in view of the fact that this conclusion is upheld by the division bench.
Well, let the agreement come on record, my lord.
File it.
Lordship.
The counsel for the petitioner undertakes to file the arbitration agreement before the court by way of a separate affidavit. How much time?
Lordship, within a day, we will file it, Lordship.
Okay. List after 1 week.
Lordship, if a date can be fixed.
You file it first and get a mention, list it. After 1 week, Mr. S. Dr. Senior Counsel, assisted by Ms. Aidas for the respondent. You are R. Borua, P. Borua.
Lordship, P. Borough.
P. For the petitioner.
Second, fourth.
What is the report?
My lord, before that, my lord, during the pendency of the case, the petitioner had expired, my lord, in November.
Oh,
During the last hearing, we didn't know that when the matter was sent to the mediation. We informed his wife
after mediation.
before mediation. So his wife participated in the mediation, my lord.
What is the claim here?
Claim is regarding, my lord, he had overstayed in his service. Because of this overstay, his extra payments were whatever was made regarding salary was deducted from his leave encashment and retirement benefits, my lord.
No, but there is a mediation report which says
There is a
that
mediation
it
report.
has been settled.
It has been settled. They say that we do not want to
Yes.
pay.
Yes.
His wife has said.
This is the letter, your lord.
Oh,
In the report, the last paragraph came out. Okay.
It is one of the.
Application.
Oh, to I said,
The last paragraph of the first page, my lord.
Oh, no,
Mm.
I've got the instructions in this matter, my lord. The grievance of the petitioner has already been met, my lord. We have already issued the PP.
you have included? You have included
We have issued the pension payment order, my lord.
to his wife.
It
It will now be FPPO.
Yes, it has been.
It's Nizamuddin Laskar.
He's expired.
He is expired.
He expired.
It's open with
Last year, December, November.
Then there has to be a substitution, my lord, because the petitioner himself doesn't survive.
Already they appeared in the mediation, your lordship, his wife. He's settled into mediation. He's involving person. Pensioner কথা নিয়ে extra saving people to extra 1 year extra pension to overstay and overstay period of what's happening today. If you say pension of the people. You can see when you take the have a increase, you can condition of the
Heard counsel for parties. This matter was referred to mediation by order dated 14/7/2025. Thereafter, the mediator submitted a report. Mediator appointed submitted a report that the matter has been settled through mediation. Stop. The report is enclosed in the file. Perusal of the report reveals that the writ petitioner, during the pendency of the writ petition, expired
On 8/11/2024.
on 8/11/2024.
2024.
That is prior to reference to mediation.
We were on, when the order was passed.
What
we tried to
mediation took
communicate.
place here without substitution?
And the PPO was issued on 5/3/2020, my lord.
On the first day only, we informed the mediator.
Huh?
We informed the mediator that the petitioner has already
But
expired.
the legal heirs were never substituted.
Never substituted.
Then how can there be a mediation? However, from the record, it appears that the writ petition expired on 8/11/2024.
8/11/2024.
Stop. The legal heirs of the writ petition, the deceased writ petitioner, did not take any steps for substitution. Accordingly, the writ petition abates. Dismissed. Mr. B. Sharma, for the
Accountant General.
Accountant General, Ms. K. Fukan for
Respondent number 124 AGCL.
AGCL, Mr. B.
AEG.
Prasad for
Petitioner.
writ petitioner. There is no instructions for substitution.
At the moment I have, if a lordship permits me, I can.
Be required because, my lord,
Already.
in the PPO, the wife's name would automatically come.
It has already come. It has already come. The claim was only.
It is also recorded, the submission of Mr. B. Sharma, the learned counsel for Accountant General, is also recorded to the effect that the PPO
Would contain the name of
was issued in favor of the
The
writ
husband-
petitioner,
The petitioner.
namely so and so, when?
on 20 on 5/3/2020.
5/3/2020. Give us a copy to Raghu, copy of which has been furnished to court and same is kept on record. The said PPO also reflects the name of the widow of the writ petitioner,
If
late writ petitioner. Therefore,
The pension
yes,
payment
the
order is in that book.
PPO will also reflect the name of the widow. It's already there.
Yeah.
Srimurti Minara Begum.
Mariam Begum.
Oh. Then I don't know. Somebody else's name is here. In that view of the matter, the writ petition stands closed, as no steps have been taken for substitution of the legal heirs. Much disposed.
Item 5.
Maybe your lordship.
Yes.
Lordship, petitioner before lordship was a government doctor working as a medical and health officer at Nilam Bazar PHC, my lord, originally. my lord. It is in Kasa, I think. Then he was transferred against the existing vacancy to Kaline CHC White order dated 7/1/2002. Thereafter, again, he was transferred. Although he was transferred, not released for long time. Ultimately, he was released on 6/3/2002. Then thereafter, he handed over the charge on that day, went to join his new place of posting at Kaline on 7/3/2002. Thereafter, matter, however, However, at Kaline CHC, there was no vacancy at all, my lord. That was just to, my lord, accommodate their blue-eyed boys, interested persons. I was rotating like a Rubik cube, my lord. No vacancy. Then, my lord, since there is no vacancy, my lord, the transfer order was modified on 19/3/2002, whereby the petition was transferred from Nilbazar PHC to Kaline again, my lord. Kaline. After receiving the said notification, my lord, on 19/3/2002, on 22/3 March, lordship, the petitioner reported the deputy superintendent of Kaline CHC on 23/3/2002, but could not take over the charge because their incumbent member Badal Das was absent. Subsequently, he obtained a stay order from the Honorable Guwahati High Court, my lord. So till his representation is disposed of, my lord. So for that order, my lord, on 17/4/2002, notification was issued staying the transfer order of Badal Das. This situation was, my lord, continuing, my lord, since the petitioner was promoted to sub-divisional medical officer, health officer, by notification number 77/12/11/7, my lord. So, my lord, later on, subsequently, my lord, incidentally, the petitioner was again transferred back to Kaline as a deputy superintendent of police. The petitioner was working, my lord,
Deputy Superintendent of?
superintendent of medical, my lord.
Oh.
Sorry, madam. Sorry. Then meanwhile, the petitioner was retired, my lord, on 31st May 2014, my lord. Because of the, my lord, petitioner's arbitrary action, my lord, my pension was, my lord, not regularized from 7/3/2002 to 26/11/2007, my lord. That period, my lord, is non-fault of mine, my lord. I was hanging, my lord. Each and every day I am writing, my lord, for instruction, my lord. So that period was not regularized, my lord. So I am not receiving any final pension, my lord, although I have retired on 2014, my lord. This is my humble, in a nutshell, my lord.
Yes, why? What do you submit?
Lordship, I have not filed any reply, Lordship. So,
That we
Lordship,
can see.
so Lordship, let it come after 10 days, Lordship. I'll file a reply in this matter. Because Lordship, I
It's
have
a question of regularizing the services.
Yes, Lordship. So,
So you have not filed from 2019, you have not filed.
6 years back, they have received the notice, my lord. All the respondent, my lord.
You have to get your instruction.
Yes, Lordship, I will get
Get
this.
it day after tomorrow.
Lordship, can it be on Wednesday then?
Tomorrow.
No, Lordship, next Wednesday. Notice of the high, I know, instruction.
We'll have it on 18th. 18th September.
Yes, Lordship.
Get your instructions on 18th,
Yes,
including your records, whatever is necessary.
yes.
Heard Mr. M. U. Ahmed, Learned Counsel for the petitioner, Mr. U. D. Upamanyu for the Health Department, C. Borua for Accountant.
Yeah, 8, 9, and 10.
Accountant General. The grievance of the petitioner is for regularizing his service for the period 7/3/2002
to 26/11/2007.
26/11/2007, along with unpaid pay and allowances from 7/3/2002 to 31/5/2014. Stop. It is the grievance of the petitioner that because of non-regularizing his service period from the period 7/3/2002 to 26/11/2007, his regular pension has not been released. Stop. He has superannuated on 31/5. On 31/5/2014. Stop. It is seen that the health department it is seen that the respondents have not filed their counter in spite of notices being issued as far back as 17/6/2019. Under such circumstances, we permit the respondents to complete their instructions in the matter and apprise the court. The matter is directed to be listed again on 18th of September. On which date an attempt will be made to dispose of the witness. List accordingly.
Item 7.
Please, Lordship. The case pertaining to the overpayment of pay and allowances, Lordship, due to the wrong fixation of pay of the petitioner, Lordship. He was retired as a supervisor at Kanango in 2017, Lordship. So I was, by the imperial order, I was asked to pay rupees 4,83,175. And my monthly pension has been reduced to, after deducting it, to 21,870, Lordship.
Yes,
Should the AG will, AG's affidavit will be required in the matter, Lordship.
why?
AG affidavit, 5 days.
Why is affidavit?
As per the Supreme Court judgment, Lordship, I am a grade 3 employee. It can be recovered from my pensionary benefit, Lordship.
That number.
Hmm?
Recovery excess.
Yes. Pension or accountant general?
Respondent number 2 and 3 has already filed affidavit, Lordship.
Hmm.
I have had the
AG file.
The accountant general has filed the affidavit.
yes, Lordship.
Yes, Lordship.
Why do you say?
Lordship, that copy is not with me. Sorry, Lordship, it was my misunderstanding.
Ah.
Lordship, I'm appearing for respondents 1 and 4 for the pension department. Could I pick one from those? Thank you, Lord. Could I pick this?
This recovery, where is that recovery notice?
At page 31, Lordship. Annex H.
31.
Yes, Lord.
When did you superannuate?
On Lordship, 31/12/2017.
Oh, I feel it's more than-
From DC office to G.
What is the component of the recovery?
Component,
House building allowance.
yes, Lordship. Arrear pay. Because
No. This is, it appears to be house building allowance. Page number 31. No, sorry.
No,
Other
Lordship,
due.
it's recovered from arrear and future reliefs on last.
Overpayment.
Yes, Lordship. Due to the wrong fixation of pay, Lordship, from 1996. I am not aware of it. And after retirement, I was informed that there was some recovery.
I think the circular itself prohibits recovery.
Yes, Lordship, excess drawl due to not due to the fault of the petitioner will be recovered, Lordship.
Was there a show cause notice issued?
No, Lordship.
Not there in the petition.
Yes, anything to submit?
Lordship, here we don't have exact instruction as to whether it was due to the fault of the petitioner or not. Lordship, show cause notice also,
There is no show cause notice.
there is no show cause, Lordship, in the petition, Lordship.
That itself is a violation of your office memorandum. You heard Mr. D. Kolita,
Yes, sir.
Learned Counsel for the Petitioner, MS U. Sharma, Learned Government Advocate.
For 1 and 4, Lordship.
For respondents 1 and 4. Mr. S.K. Medi for respondent 2 and 3. And who's for 5? MSA Botagul for 5 and 6. Stop. Petitioner before this court was serving as supervisory kanungo and subsequently he superannuated with effect from which date?
31st, 31/12/2017.
31/12/2017. So the petitioner was receiving his pension when he was served with a recovery order dated 11/1/2019 issued by the Accountant General's Office, whereby an amount of rupees 4,32,489.
83, Lordship.
83.
483.
483.
Yes, Lordship.
Sorry, 483,175
Yes, Lord.
was sought to be recovered from the petitioner from arrear and future relief for overpayment of pay and allowances. Stop. Did you file any representation before the authority?
Yes, Lord.
It's not enclosed here.
Yes, I have enclosed, Lordship. Page 30.
Petitioner thereafter represented before the no, page 30 is your is the communication by okay, petitioner thereafter represented before the office of the Accountant General requesting for dropping the proceedings, dropping the procedure for recovery of excess pay as according to the petitioner, he has received the pay which is reflected in his service book. Stop. Copy of the said representation was forwarded by the Office of the Accountant General to the Office of the Additional Deputy Commissioner, cum Pension Officer, for which district?
Thubri, Lordship.
Dhubri. Stop. However, no steps being taken by any of the authorities. The petitioner has approached his court, questioning the recovery sought to be made by the order dated 11/1/2019. Stop. The learned counsel for the petitioner has pressed into service the judgment of the apex court rendered in Rafiq Masi, reported in so-and-so, to submit that the petitioner is a grade 3 employee and the pay and allowances which was stated to be and the overpayment of pay and allowances stated to have been made to the petitioner was, if at all, was not cannot be attributed to the petitioner. Stopped. He had continued to receive the pay and allowances, which is reflected in the service book. And during his service, no steps were taken by any of the authorities to intimate the writ petitioner that he had been overpaid and attempts have been made to recover the same. Stop. Now that he is superannuated, the attempt for recovery is barred by law, as has been decided in the judgment of Rafiq Masi, reported in so-and-so. Stop. The counsel for the Accountant General submits that the recovery is to be made as it was found that the amount of rupees 4,83,175 was found to be overdrawal by the petitioner in respect of pay and allowances. The counsel for the state submits that there is no instructions available, and it is submitted that she be permitted to obtain required instructions in the matter. Upon hearing the counsel for the parties and upon perusal of the pleadings on record, and as also upon the careful perusal of the judgment of the apex court rendered in Rafiq Masi, reported in so-and-so, it is seen that the judgment had laid down the following directions. So, based on these directions, the Government of Assam Finance Department has issued notification number so-and-so, dated 14th of June 2019, on the subject of recovery of wrongful/excess payments made to government servants. So, in following the directions of the apex court, the recovery by employers has been specified to be not permissible in the following cases, page number 40, paragraph 4, extract. So, having noticed the circular, it is seen that so far as the writ petitioner is concerned, he belongs to class 3. He's a class 3 employee. He was a class 3 employee. He had already superannuated on which date?
31/12/2017.
31/12/2017. And where excess payment has been made for a period in excess of 5 years before the recovery is issued, is prohibited from making such recovery. Stop. The writ petitioner was given the excess payment in terms of allowances and pay well before he retired from service. Stop. That apart, in terms of the notification, before making such a recovery, the show cause notice is required to be issued by the employer. Stop. Admittedly, no such show cause notice has been issued. Stop. It is seen that where excess payment can be attributed to the employee on the ground of fraud, misrepresentation, collusion, favoritism, negligence, carelessness, etc. Only then recovery, notwithstanding the exceptions carved out, is permissible. Stop. In the facts of the present case, no such finding has been arrived at by the authorities concerned, as has been placed before the court. The authorities have not issued any show cause notice requiring the petitioner to respond as to why the recovery ought not to be made. Stop. Under such circumstances, the authorities, more particularly the additional deputy commissioner cum pension officer, Dubri, cannot proceed to recover the amount from the petitioner from his pension payable without following the procedure prescribed in terms of the OM number so and so, dated so and so. Stop. Accordingly, this court is of the view that in the absence of any instructions forthcoming from the Department of Finance or from the additional deputy commissioner cum pension officer, this court is of the considered view that the matter should be closed with a direction to the additional deputy commissioner cum pension officer to not to recover, to refrain from the process undertaken for recovery of amount of rupees 483,175 without following the procedure prescribed under the office memorandum dated 14/6/2019. Stop. The writ petition therefore stands disposed of with the above observation. The recovery sought to be made from the petitioner is therefore set aside, disposed.
Please, your lordship, here lordship petitioner has no objection. Matter may be referred for mediation. Lordship.
Yes, Lordship, 2-1 and formal divorce has not been taken place.
Both counsel submit that the matter can be referred to mediation accordingly. Matter be referred to mediation to be listed, to be placed before the mediation on 26th of September.
Highly obliged.
Paid order to Commodore Marini. Mr. S.K. Medi for respondent.
Other respondent 1456,
Mr. C.K.S. Borua for
14567 and 2, Lordship, 2. 1 except here. All the respondents except here.
1,
1, 2, 4, 5, 6, 7.
6, 7.
Muslims.
Highly obliged.
In this case, I am paying for examination money for today, minus. Senior is annual money. Therefore,
Lordship, this matter is not fit for mediation. It's regulation of service. He's a master of worker, my lord, already retired. He got all the retirement benefit as a master worker. And regulation, Lordship, he joined in the service in the 1/6/1994. So after 1/4/1994, Lordship. So it's regulation, it's not possible.
next time maybe taken, my lord.
I have filed affidavit, my detailed affidavit I have filed.
All right, matter since this is the prayer for regularization.
Yes, my lord.
Yes, ma'am.
The claim before the writ petition by the writ petitioner is for regularization in the post of
Lordship is a work as a
Great
lordship.
scheme, my lord.
Master or worker worked as a lordship.
Works as
Works as employee lordship. Post name is not.
as he's been rendering service as a master role work charge
Yes.
employee.
Yes.
The counsel for the petitioner also submits that the matter be deferred to be taken up after 1 week, as the arguing counsel is in this post. Accordingly, let the matter be listed after 1 week. And since the matter pertains to the claim made by the petitioner for regularization, both parties submit that cannot be resolved through mediation.
Yes.
Okay.
Obliged lordship.
Item 10.
No, your lordship. Similar issues is pending before the Honorable Supreme Court in Civil Appeal number 451425. Pertains, my lord, pensionary benefits of workers to employees, my.
Yes, pending.
My lord, pending,
Yes, sir.
otherwise, Upen Das is very clear on it.
That was challenged before the.
That is challenged in the Supreme Court.
Upen Das is assailed
SL, my lord, in Supreme
before the Supreme Court.
before the Supreme Court. My lord.
My lord, in
So, my lord-
Civil Appeal number 4514/2025.
It's no point sending it to,
Right. The counsel
Yes, ma'am.
of the bar submits that issues raised in the writ petition is pending before the apex court in civil appeal number
4514/2025.
4514/2025.
2025, my.
And
Of the copy.
therefore, the matters is required to be deferred till any such orders are passed in the said matter. Considering the submissions made, matter stands deferred to be listed after 8 weeks.
Fine, your lordship.
Item 11.
Eight is allowed. In this matter, I need a week's time to get some more information.
Huh?
And I need a week's time. So I'm not able to.
Counsel for the petitioner prays for a week's time. But this is to be referred to mediation.
Lordship, this cannot be referred to the mediation, Lordship,
Oh.
because in this matter, they are seeking compassionate family pension, Lordship. Because the board, it is not a government, Lordship, and this has been held by the Honorable Supreme Court also, Lordship.
All right.
So this point needs to
Matter be
be
listed after 1 week.
deeply.
Ms. M. Bhattacharya, another additional senior government advocate, appears for the respondent. Yes.
Deeply.
Item 12.
May I please, lordship? Lordship, this is a pensionary benefit, lordship.
Mediation.
Yes, lordship. Lordship, we inform our client about this matter mediation. Lordship, she says that if the respondents fulfill all her prayers, then only she will go for mediation.
Therefore, go to mediation. Unless you go to mediation, how do you know whether they will fulfill or not? Parties are referred to mediation, as submitted by the counsel parties. Yes.
Okay.
May I please, Your Lordship, as per the last order, we have received our instructions from our clients and we are not resorting to mediation. It's a matter pertaining to non-payment of family pension.
Family pension by whom?
By the Forest Department, non-payment of family.
Why?
pension. Lordship,
Why has it not been paid?
because there's a gap in his service. And due to that procedure, I mean, we're not resorting to the mediation. We also have to file our amended cost title, including respondent number 7 and 8. So we'll be
Who
filing.
are 7 and 8?
Secretary to the Government of Assam in the Finance Department would be implemented as respondent number 7, and Treasury Officer Sipsagar as respondent number 8. Will you filing our amended cost title shortly? Let the Forest Department file their reply.
When were they impleted?
We will be implementing very shortly.
You can't implement unless there's an order of the court.
13/9,
Huh?
13/9/2023.
13/9.
Yes, Your Lordship.
Then why have you not implemented them?
We'll be filing our amended cost title shortly, Your Lordship.
We are dismissing your petition. Why for 2 years you have not implemented in spite of an order being passed? It appears you are not interested.
No, we are interested, Your
Then
Lordship.
why have you not filed?
We'll be filing it shortly.
File it within by Monday. List on Monday.
Lordship.
Enabling the petitioner to take steps for filing amended cost title in terms of the order dated so and so, or order to sign over. Yes.
Most of.
That is 14.
Though Lordship, matter has been referred for mediation, there is no instruction on the part of the petitioner, Your Lordship. Probably, Lordship, the pension benefit has been received by the petitioner, probably, Your Lordship. It's no certainty. So, Lordship, I kindly fix the matter after a week so that I can obtain the instruction.
You go for mediation, and then if she has received it, you will close it there.
Yes.
Lordship.
Matter be referred for mediation. Be listed on 26th. Mr. Adhor for? Adhor for? PWD, SK Medi for? AG CKS Borua for? Respondent 1. G Bora for petitioner.
For hearing item 1640.
Lordship may take item number 3 first. Item number 2.
5950. Writ
Lord-
petition number?
Lordship, item number 2, Lordship. Because
Oh, item 2. Okay. Item 2. Yes.
May I please, Your Lordship. Lordship, in this case,
Morton Stowe.
yes, my
Morton.
lord.
Yes.
So on the last occasion, my lord has directed the respondent to.
What instructions?
Lordship, though Mortem is not reflected in the our guidelines, Lordship, but Mortem is the one of the deficiency, Lordship.
On what basis are you holding it?
Lordship, on the basis of the medical report, Lordship, he has got the Mortem's.
Medical report says Morton Stowe, yes.
Yes.
But whether it is a defect or a deficiency for being recruited in service, there has to be a finding that they are, because of this,
That was
they
there.
are unable to put on the combatized shoes. or
Footwear,
something.
yes.
That only the report says, Lordship.
Morton's is one extra.
Yes, no, my
No,
lord,
Lord.
not one extra. The second toe is longer than the big toe.
Big toe. Only that's Lordship in our
Second
report.
toe is longer than
Big toe,
Big toe.
the thumb.
Thumb.
yes.
Hmm.
It's little bit longer than the big toe. So whether it's
Where is that?
whether it's
the finding
impaired.
there? What basis you are rejecting people like this?
This is on the basis of only the Mortem toe is there in our report, Lordship.
No. Who in the authority takes a decision that it is good enough to be rejected? There must be a set of guidelines, there must be a set of rules or some circular to say that you can't use it. Or there has to be a finding that because of this, we have noticed that she is unable to put on the combatized shoes. footwear.
That observation is not there.
Then-
It's a common anatomical variation. It's not a defect.
You see, you are rejecting people.
Lordship.
You must give a proper guideline so that people know on the basis of what parameters they are being rejected.
Lordship. Please, Lordship, here, Lordship, in this Morton 2, Lordship, that observation is not there. Otherwise, Lordship, the clinically proven other deficiency. Morton 2 is not there, Lordship. But this is one of the deformity because of not wearing Lordship may direct us
No,
to.
deformity must be specified somewhere.
Lordship,
Where is it specified?
Morton 2 is not there.
Well,
Lordship may direct us to re-verify and give him observation with the detailed observation why his.
why should we re-verify?
Exactly. That in this case, Lordship.
So why should we re-verify? Unless you tell us that it requires re-verification.
Lordship.
You must tell us that no, it was not verified, or this part was left out, or this circular was not taken into consideration.
The circular not yet taken consideration, but the the medical board has observed Lordship, but not detailed observation was given. The only
Where is the observation of the medical board?
My lord will find at page 83. Detailed medical examination.
83.
It's simply saying Morton's toe bilateral. Means in both foot.
No, this appears to be a typed copy.
My lord will find at page 85 then.
85.
Original.
What is B oblique L?
Bilateral means both foot.
Did you apply for review medical?
Yes, my lord.
This
Thereafter
is
review
after- this is
review
after the
medical
review.
examination was also done. My lord will find at page 88. So same, my lord. X-ray was done. So Morton's toe. We are not denying we have Morton's toe, but whether it's a deformity. So my humble submission is that it's not a deformity under the general grounds for rejection, and it doesn't impair for wearing computerized footwear.
Is there anything you would like to rely on? On what basis they are rejecting it?
Lordship,
There
Only
must be
the-
some circular, something.
that only the basis of a review medical board, Lordship, they have rejected because
No, see, they have written unfit.
unfit on account of Morton to BL.
So these unfit.
The reason was not given that he cannot wear the combatized Lordship.
Where is that medical board circular or
Lordship.
is something is there, no modified ones?
The revised guideline, my lord.
Revised? Where is it?
I have supplied, my lord, on the last occasion, maybe in the
Records.
record file itself.
The revised guideline as indicated.
Page number 25.
Page number?
My lord will find at page 7, my lord. Internal page 7, general grounds for rejection. The revised guideline. In the revised
No,
guideline.
about the foot.
Regarding foot, my lord, will find at page 23.
Page?
23, my lord. It starts from page 23.
Internal page.
Internal page, my lord.
27 of the Oh, yes, yes.
Lordship, it will be in 27. page
But
number
it starts from deformity and their assessment. Knock knee, my lord will get that. Thereafter, bow legs and flat feet. It starts from flat feet. And thereafter, hemato is also there. But there is no mention of Morton's though.
only thing, Lordship. is
Hematos are there, Hellas felgas are
botanic
there.
presence of deformities of the toes are there, Lordship.
Presence of deformities of toes,
Toes.
Yes,
including but not limited to.
yes, my lord.
That-
Including but not limited.
Ah. So
Our-
is this a deformity?
Yes.
They, according to them, it is a deformity.
Deformity.
But my lord, it's not a deformity, it's an anatomical variation. So whether it's a deformity or whether it impairs for wearing the competized foot so they have to give a reason. So they couldn't give any reason, my lord. The opinion was in short, it
No.
was incomplete, my lord.
No, no. The first question is whether it is a deformity.
My lord. So
It is
in
a
the
deformity.
in the list of rejection, so there was no mention of Morton's though, means it's not a listed defect.
May not be, but it says not limited to.
Yes.
May not be, my lord.
Ah.
But how it will prove, my lord, that that particular Morton's toe is it impairs to wear the foot competized footwear. For that,
They are the experts.
my lord,
They have decided that it is.
but there is no opinion that that she was examined with wearing with competized footwear, my lord.
The medical doctor or the medical boards,
My lord,
they are not judicial officers.
maybe.
So their finding
My lord,
it could be one term, one phrase, one word. According to them,
I bow down, my lord. But
this is a deformity.
my lord, I bow down, but it's apparent from the opinion, my lord. It's they have simply written that okay, X-ray has been done. So Morton's the bilateral, so in unfit.
See, there are two. The reason I'm asking you are because of two reasons.
My lord.
Number one, if it is not a deformity, there are two concentric circles. One is whether it is a deformity.
My lord.
If it is a deformity, whether it prohibits you from wearing competized uniform. This is the other.
Yes.
But if it is not a deformity, then the second question
doesn't come.
Doesn't come.
Doesn't come, my lord.
But
yes, my humble submission is that it's not a deformity.
submission itself is not enough. It is a technical term. You'll have to come up with some material to show that it is not a deformity. Number one.
My lord. Since in the list of defects, my lord, there is no mention of Morton's toe. So that's why my submission is that it's not a
no.
Even if,
List
my lord, even if it is considered that it's a deformity, then also they will have to prove it. That
we are passing judicial orders.
My lord.
You are questioning the report of the medical officer that it is vague.
My lord.
Judicial orders cannot be vague. We
Definitely.
have to come to a conclusion whether it is deformity or it is not a deformity.
My lord.
If it is not a deformity, the second area is not even required to be gone into.
My lord.
But if it is a deformity, then there is a question of maybe there could be a requirement of further review board to come to a conclusion whether it will prohibit you from wearing.
Impairing, yes, shoes and.
But it is for you to impress upon the court to satisfy whether it is or it is not a deformity. The analogy which you are trying to draw may not be safe to accept. Because there could be hundreds of deformities. Whether in medical terminology, is it considered to be a deformity or not?
My lord, in medical terminology, as I have researched in something, so I could find that it's not a deformity, it's an anatomical variation. So people might have this, my lord. Someone has short toe, second toe is shorter than the big toe. Someone has slightly longer than the big toe, my lord. So it's an analogical variation. And suppose if we get that scientific research says that in 100 people, my lord, it's more than 20% will get Morton's to, my lord. We'll find, my lord.
Okay. Then this is one.
Lordship.
Then what are the other matters? Is there any other Morton Stowe or disability?
Worship, my matter is also same Morton Stowe.
Morton Stowe.
33.
33. Sound 33.
My lord, before coming to that, I want to rely a judgment, my lord, of honorable. The Honorable Delhi High Court judgment, my lord.
Citation.
Citation next, actually, WBC number was 6142 of 2012. My lord will.
What is your item? What is your case number?
Item 2, my lord.
In WBC.
My lord, from paragraph number 1, my lord. This is probably the 50th matter dealt with by this court pertaining to the medical fitness standards applied while certifying fitness of persons who successfully cleared a medical of the examination for being appointed to various posts in central paramilitary forces. So in that case, my lord will from paragraph 4, my lord, there was deformities, my lord. The petitioner successfully cleared the selection test to be appointed as assistant commandant pertaining to CAF, assistant commandant examination 2011, but when medically examined to June 19 to 2012 was declared unfit with reason cubitus valgus. The degree of angle has not been stated. The petitioner got himself examined by an orthopedic doctor at Apollo Hospitals International Limited, Ahmedabad, so who certified as per certificate dated so that both the elbows of the petitioner have a carrying angle of 11 degrees on both sides. Same is the opinion recorded in the certificate dated so issued by the civil hospital at Ahmedabad, when even the senior medical officer hospital has certified that the carrying angle of the petitioner was found to be 11 degrees. Suffice it would be state that as per the notification issued by the Minister of Home Affairs pertaining to males, the carrying angle should be more than 15 degree. Doctors are repeatedly opining that the carrying angle of the petitioner is 11 degree, and it needs hardly any emphasis to be brought out by us that 11 is less than 15. It is to be regretted by us that the BSF doctors are not keeping in mind the prescribed standards. Instant case highlights the same. Personally, every day a writ petition on the subject of medical fitness is reaching this court. We direct that henceforth, if any doctor of any central paramilitary force would give an in-short opinion, we will treat it to be a case of contempt. We direct that henceforth every doctor or a board of doctors of every central paramilitary force, while conducting the medical examination of a candidate, if finding the candidate to be unfit, would record the parameter with reference where unfit has to be opined, my lord. A reference would be made to the requisite standards prescribed or known to be prescribed and accepted as such by the experts in the field. Any such certificate issued hereinafter which does not so prescribe would be treated as an act of defiance of the orders passed by this court, and for which the additional director general kept would be possibly liable. So there must be some reasoning, my lord.
I have one more judgment from the Allahabad High Court Lordship.
Dada, yes, एक minute. Page para 25 lordship.
Yes,
Mayor lordship.
yes.
I got it. This
Yes.
court in the case of Vivek Kumar Supra held that the subsequent medical examination report submitted by a candidate will not override or set at naught the opinion of the medical board. Paragraph 7, 11 and 12 of the same judgment are being extracted here in below. The scope of interference in matter relating to the assessment of fitness by a medical board constitute under the statutory rule in exercise of power under the writ jurisdiction, in our opinion, would be extremely limited. The courts have time and again emphasized the need for cautious when candidates seek to assail the correctness of the findings of the medical board constituted under the recruitment process adopted by the state authorities on the basis of some medical report obtained by them. In the case where a recruitment process has been carried out as per prescribed statutory rule, whereunder a procedure has been prescribed for testing and medical fitness of the candidate by a duly constituted medical board, the report of the medical board is not to be normally interfered with, and that too solely on the basis of claims sought to be set up by the candidate on the basis of subsequent reports procured by him from a private practitioner. It is not the case of the petitioner that the decision of the medical board has arbitrary, capricious, or not in accordance with the procedure under the relevant statutory recruitment rules. In the case of so-and-so, Supra, the court placing reliance upon the judgment of this court in the case of Vivek Kumar Supra dismissed the appeal, holding that in absence of any material on record to suggest that the opinion of the medical board or the appellate medical board in any manner is casual, prefectionary or vague, the report of the medical board and the appellate medical board are not to be interfered with. It is further held that the opinion of the medical board is to be given to due weightage, credentials, and the value. In case the reference of this case is there, Lordship. In the case of Dwarka Paswan Supra,
No, no, what is the issue here?
Here, rejection by the medical board, unfit declared by the UP selection. Police recruitment, UP police recruitment is. Exactly. Review of medical board fitness, police concept, disability, authenticity of the malafide. If there is no malafidness in the process, Lordship, the five double 6 8 21 double 6 8 2020. Alaban, no? 811. কোনটো বেৰা? 29.
Here you have, here is a case where the court declined to interfere
Lordship.
because there was no
In
cloud cast, there was no doubt cast on the review medical.
yes. Here also
There was a contrary report.
but here is no contrary report. Here the from the Guwahati Medical Board, the Mortento is there.
No. You see, in this case,
No.
there was one report saying that there was a defect in his hearing,
Hearing.
and private hospital said no defect.
No defect.
So the court refused to accept on the ground as to why that is correct and this is wrong, etc. Here is a case where the finding itself does not reflect that it is a disability. The rules don't say, the circular does not say it is a disability.
Our as for my affidavit, Lordship, and because of the presence of deformities of the toes, that was the ground taken only, Lordship. As Mortento is one of the defects, specifically Mortento is not there.
You come to your
Guidelines, Lordship.
the guidelines. You come
Lordship.
to the aims, page number 2, internal page 2.
Lordship.
The aims is to ensure medically fit personnel,
Lordship.
free of contagious disease, free of medical conditions, as would lead to loss of man hours on the ground of medical so and so, medically fit, physically capable of satisfactory completing. All these will have to be satisfied
Lordship.
before you say that the person is unfit. So there must be an internal decision somewhere that these it could be there.
Yes.
By way of experience that these people are not able to do a particular task required because of the anatomical variation. Possible. So that finding from some document, some record, if you're able to place it before us, we can examine it.
Lordship, F is there, free from physical defect, infirmity causes any hindrance in proper wearing of the uniform.
Exactly, but where is the finding?
The finding is not.
Where is the finding that this will hinder?
Lordship, that was apparently
and
not.
And while you are doing a medical test,
Lordship.
Perhaps what is required to be done is to have the parameters. That if that particular toe is beyond such and such centimeters or millimeters, it will hinder wearing of the combatant shoes. Or you physically require the recruit to put on the combatant shoes and find out.
Yes. Lordship. Apparently, Lordship, in this case, that was not there. Only that opinion was there. But
all right. What about the other writ petition?
There are other deformities are there, Lord.
The item number 33?
33 is mortem. Mortems.
Only mortem.
Lordship.
Mortems. So initially,
where is that page number?
Lordship 46. The review medical report, Lordship. Page 46. Type copy is at page 45, Lordship.
Morton's toe.
Initially, under DME lordship, I was rejected for exotropia, scoliosis, and mortal stroke. And review medical board rejected only on the ground of mortal stroke lordship. Page 46 lordship. 3 final opinion. A, B.
Where is the medical board opinion?
Lordship, medical board opinion, I have only annexed this. Medical board opinion, Lordship, point 1, Lordship, reasons for medical unfitness, Lordship, point 1. 1 to 3, Lordship. Exotropia, scoliosis, and mortal stroke, Lordship. And final opinion of this Lordship review medical board is at 3B, Lordship, unfit on account of mortal stroke. Within bracket congenital anomaly.
Okay. These are the two matters.
Lordship, for Morton toe.
Item 19, Lordship, for hammer toe, Lordship. Item 19.
16 also.
All right, we'll pass orders in these two matters. Let us see if there are any other matters available. This is item number,
33.
no, sorry, one is item 2. $33. And item
19 for hammer stone.
19.
19 hammer stone.
Let us see.
Lordship, the rejection is at page 64. At point 1, reason for medical unfitness, left foot hammer toe. And in the brief of review, medical examination and findings.
Chronic fracture of right.
Yes, Lordship. So it's contradictory in their own medical opinion. And thereafter, Lordship, he has done X-ray in Fakhruddin Ali Ahmed Medical College. The report your Lordship will find at page 71. The doctor's advice slip.
Page?
Page 71, Lordship. No abnormality seen. Callosity present. Admittedly, his 1 feet is, there is a hammer toe, Lordship, but there is no fracture, Lordship. And the Department of Radiology, Lordship, the X-ray report, Lordship, at page 72. X-ray bilateral foot, AP, LAT view. Bones are under review intact. Articular margins are smooth. Joint spaces are maintained. Soft tissues shadow normal. So firstly, they said that he had a left hammer toe, and in the review medical board, they said he has chronic fracture on the right foot. He has also filed a representation, Lordship, before approaching this honorable court. And in the year 2022, he has passed the PET of State Level Police Recruitment Board, Lordship, the medical of State Level Police Recruitment Board for the Assam Commando Battalion. Lordship, my only prayer is that since there is a conflict of opinion, Lordship, he may be referred for another medical board, Lordship.
What is hammer toe?
Hammer toe is the toe is a little bit bigger, Lordship, than normal size, Lordship.
Page 26 of the guidelines.
26 of?
In the guidelines, medical guidelines. Internal page 26. Hammer toe is there, Lordship.
Hammer toe is specified.
Yes.
Specified, Lordship.
Then?
No, Lordship, thereafter he did X-ray, Lordship, in Fakhruddin Ali Ahmed College, Lordship. But he has not been rejected for hammer toe, Lordship. He has been rejected for chronic fracture. Review medical board. Their own
Chronic
medical
fracture.
boards is contradictory, Lordship. He has been rejected for fracture of right great toe. There is no fracture in his feet, Lordship. And they have not annexed any X-ray report as well, Lordship, in their affidavit in opposition.
What do you say?
In our the record, there is X-ray is there and fracture in right grade toe is there, Lordship.
Yeah. What about the other two?
The hammer toe.
Hammer to
Not hammer toe, the
Morton's toe.
Morton's toe. We have the medical records.
Yes, here no medical, Morton toe is not there, hammer toe is there. Rejection is on the ground of hammer toe.
No, rejection is on the
It's on the ground of fracture.
Fracture, Lordship.
here it is in this item.
Yes,
Here is this fracture.
It is
Rejection.
there.
there.
Yes, Lordship.
There is a report.
Yes.
It is there.
Lordship, only my only submission is that since there is a conflict, Lordship, I'm placing reliance on a order of this honorable court, Lordship, where there was a conflict, Lordship, it was referred to a independent medical board. I'm not even seeking for independent medical board, Lordship. All I'm seeking is let him go for another X-ray, Lordship. If he has fracture, he will be rejected. If he do not have fracture, then he will be appointed, Lordship. Because their detailed medical examination rejection is different from the review medical examination, Lordship.
This review medical is held where? In the group center?
In group center, he has referred to diagnostic center, Suraksha Diagnostics.
That is also
This is a private.
Private, we have referred, Lordship.
You don't have any internal facilities.
Lordship, because of the X-ray, all of this, we have specified, Lordship, doctors where to send this. They are the enlisted diagnostic center for the central, Lordship.
Petitioner has done in a government medical hospital.
Some were done in government, some were done in the Suraksha Medical, is a listed hospital, Lordship.
In that case, Lordship, the petitioner fell short in height and eyesight, Lordship. And he annexed some documents from Government Medical College. So this honorable court directed the petitioner to be checked in Guwahati Medical College, Lordship. I'm not even seeking for an independent medical board. All I'm seeking is he may be re-examined one more time, Lordship. If deformities are found, he may be rejected.
You go and examine yourself. Why do
Lordship,
you
I have examined. I have annexed the
examine
document,
before-
Lordship.
before the hospital and tell us?
Lordship, it is here at page 66, Lordship. Fakhruddin Ali Ahmed Medical College, Annexure D, Lordship.
66.
Yes, Lordship. Patient came
Where
from-
is the report?
Report is here, the advice slip is here, and page 67 is the report, Lordship, radiology. Department of Radiology.
Page 66, here is there no callosity present over the middle aspect of grade 2. And it is also a deformity, Lordship, as per our medical guides. Callosity
X-ray
present.
report within normal limit, Lordship. An X-ray report is at page 67, Lordship.
This you have done it in a different place. Guwahati Medical College.
There is one more, Lordship. Yes, Lordship. Lordship, in the additional, but it is done by him only.
Where is callosity here? It is a deformity.
Yes, that's. As per our medical guideline, page 26. 2 number point. 5. 5.
It's very clear here if callosity is present. Then
Velocity is present, but he was rejected on the ground of fracture, Lordship.
whatever it may be.
One chance for him, Lordship.
No,
He
no.
has even secured.
It is your medical report which
Yes, Lordship.
shows callosity, which is a
That
ground
was
for.
in detailed medical examination. Review medical examination says he has fracture.
You are relying on a medical report.
Yes, Lordship.
Your report says callosity is present. Callosity is shown to be a defect. Ground for medical.
All I am seeking is a.
You are seeking it because it does not reveal any fractures,
Lordship.
but it reveals callosity. So where is the ground to go for review medical board? Maybe they have rejected you on fractures, not on callosity. But if you show this, then callosity is also a ground for rejection.
Leave it to your Lordship. I'll leave it to your Lordship.
You leave it to me, then we'll dismiss it.
My prayer is for another medical board, Lordship.
No, your prayer is for another medical board, but on what ground?
On the ground that there is already a conflict in their.
No, there is no conflict. There are many views in the original medical board. Subsequently, were rejected on the ground of fracture. Then you go for a private medical review. They say that there is no fracture, but there is callosity, where callosity is also a ground. So what for medical review board is required now? Unless you want to interpret this. All right. We'll dismiss your petition.
Lordship.
This is item number
19, Lordship.
19.
Item 16. Item 16. Yes,
Scheme.
Skin hai robo, mutton toast to yes.
Morton to.
The order passed through.
Nahi robo. Mutton toast.
Total 47.
Yes.
Yes, whatever. I think item 2, then item
Mutton toast नहीं
would vitiligo 33. Yes,
Deformity to. Yes, a deformity to yes.
16. Yes. Which is item 16.
16 is some other skin diseases there.
And 17 is also some skin disease. Lordship is taking up 16.
Who is appearing for 16?
16 I am appearing, Lordship.
This 43 is.
Ah.
43 is the rejection order, Your Lordship.
Forty-three.
43. White places on upper backs.
43.
43.
Yes. This is review medical.
A review medical.
Ah.
And in detailed medical examination, Your Lordship, that is at case 165 of the affidavit in opposition.
Detail?
In the detailed medical examination, the ground of rejection is at page 165A of the affidavit in opposition. The same ground, Your Lordship.
What is that ground?
Herein also white faces, upper back, anemia.
আপনার petitioner নামটা কি আসলে?
Nur.
আফজাল হোসেন।
Yes, yes.
ওটা নুরুল আমিন কে লিখে দিয়েছে।
Nur Ahmed
আফজাল
নাম
হোসেন তো দিয়ে জোরদার শুনবেন।
In the medical investigation report, Your Lordship will find at page 175. of the affidavit in opposition. And certain tests were conducted, case 170 plus of the affidavit.
Yes.
And 176, your lordship, this is the report regarding serum iron and serum ferritin. These two components were found within the range. But in CBC test, some of the component of the blood were found here and there, your lordship. And 179, your lordship, and thereafter all the reports were referred to the medical expert, and the medical expert opens his opinion, your lordship, that is at page 179.
179 is OPD.
Yes.
OPD, Lordship, kindly see the last line, last paragraph. The present condition is treatable condition. That means, Lordship, deformity is there at the present time. That's why he was rejected.
The present condition is treatable condition and
Treatable,
does
okay.
not cause any risk for the patient and is not a contradiction for the job. This is the view given by the medical expert.
No, treatable is a different issue.
Different.
Supposing in the line of duty you suffer something, whether it is treatable or not is a different issue. But
here
your entry into the service has to be, that is the whole purpose of
Yes.
medical fitness. This is not a medical camp to find out what deformities you have.
But nowhere, your lordship, the expert opines that regarding communicable or the tendency of the
Is this
spreading
one of the listed
Yes.
deformities?
Lordship, I'm giving.
if it has a tendency of spreading, then it is deformity. Your lordship. But herein, the expert has not opened like this. Whether it is communicable or spreading.
Mr. Roy, I
Lord.
think it is better you classify the matters, then it becomes easier for the court to deal and close the matters instead of doing it individually one by one.
Lordship.
We have found out two Morton store. One
Lordship.
is another orthopedic disability.
Lordship.
So you classify these matters
Lordship.
and you let us know at 2 p.m.
Lordship. Lordship.
item wise.
Lordship.
You talk to the councils, you cooperate with the
Lordship.
learned CGC so that it becomes easier for us to close. Then we can close these matters by a common order in respect of some of the matters at least, instead of passing individual orders.
Lordship.
All right.
Lordship.
We'll come back at 2.
Lordship.
Yes. Yes.
Lordships. No. 16 item.
Okay. What about the other matters? No similarity.
No similar. Others are different, Lordship. Today's Lordship, I have skin matters we have taken.
Okay. Right. Yes.
Basically, herein the issue, white spot on the scheme, your lordship, in initial stage in the details medical examination at the time his candidature was rejected on that ground. In detailed medical examination, he was found deficiency of white spot on the skin and anemia, your lordship.
Where is that finding?
That is in the additional affidavit filed by the respondent, your lordship, at page 174. This is 164 of the affidavit of image. This is the finding of the DME.
Hundred 64.
Okay, then what about review?
In the review is at page 43 of my read petition. Your Lordship.
Thereafter, Lordship, he was sent to GMC
Hmm.
for opinion for the recruitment.
And in the review medical board, certain examination were conducted, and thereafter the reports were sent to the medical experts of the GMC, and that is at case 44 of my read petition.
That says, Lordship, the present condition is treatable. Condition doesn't cause any risks for the patient is not a contradiction for the job. But we have rejected because the disease was present there, Lordship. In terms of our medical board, Lordship, we have stated, Lordship, tinea versicolor in neck, upper and lower back present. It is extensive and so it is not acceptable as per page number 7, point number 19 and page 34, point number 3A of the recruitment guidelines, May 2015.
But there is no any indication in the report regarding tendency of spreading of the disease. But in the rejection slip, they have written that
No, there is a difference between a disease and a deformity.
Yes.
the
Medical condition.
I am only saying about the deformity only, Your Lordship.
This is not a deformity. It's not a deformity. How is it a
The
deformity?
deficiency for which the candidature of the petition has been rejected. Regarding that, Your Lordship, there is no any opinion whether the deficiency for which his
It is
candidature
in
has
our
been-
guidelines,
Where is it? Guideline?
Lordship. Page number, we have page number 7, 19 and 3A of page number 34.
Page number 7.
7, 19.
What is the disease here?
Chronic skin diseases like vitiligo, leprosy, SLEs,
No,
enemas,
what is the
chronic
disease suffered by the petitioner?
Lordship, in our
White
versicolor in neck and upper and lower back present.
tinea versicolor. This region and upper and lower reach.
3A 34. Page number 34, Lordship. Page number 34.
34 of the guideline.
Yes, Lordship. 3A. Skin diseases like examining inguinal region and genitals. 3A. Skin diseases like boils and fungal infection. These diseases are common in the scrotal skin and groin and may kindly extended to the hips.
This is not the area.
Tinea versicolor in neck and upper and lower back present.
You are referring to 3A.
Yes.
3A.
Yes, one
3A
is
doesn't talk about neck and upper back.
But skin diseases, Lordship, is there.
Skin diseases, but what is the disease suffered? Patches.
White patches, Lordship.
Is it available here?
no. In page 43, Your Lordship, tinea versicolor, beach region and
These are the-
upper and lower beach region.
These are the
It is
skin
giv-
diseases.
It is given in the rejection, but in page 107, What my friend is relying, your lordship, that is not mentioned there.
No, are you saying this is not a disease, Mr. Counsel?
But herein one more, your lordship. Herein given if extensive, your lordship, that word is written in here.
Yes, Lordship, in
But
our
if
report,
extensive,
it is in our report, Lordship, hernia vascular in the neck, upper and lower back present. It is extensive and widespread. So it is not acceptable as per page 7.
but that is not in page 44, your lordship.
Page 44.
Case opinion.
But this is, but the present condition is treatable. That means he has that patches, Lordship. Wait. Because it is referral by us only, Lordship, to review this.
What is the meaning of this? Give us a definition in
This is the opinion of the doctor, Lordship.
what is this particular deficiency which is mentioned at page 43? What is it? What is the meaning of this?
But what I found from the Google, your lordship, it only, I have found that it is the deficiency which may cause for the deficiency of vitamin B12.
Google is not an authority, na?
This is the opinion of the GMC, Lord. The prior page was the refer to the GMC and this is the GMC
No, this is,
by our officer.
you have referred it.
Yes, then this is the report by the GMC, Lordship.
It will put out with the opinion actually.
No, this treatable doesn't necessarily mean it is a disease.
But it is, deformity is there and their opinion says, Lordship, there was the patches were there.
Hmm?
The opinion given by the doctor, Lordship.
Your doctor,
No, Lordship, GMC doctor,
GMC doctor.
Lordship.
Advice is present condition is treatable.
Treatable. Treatment is not our, Lordship. Our concern is whether he has the deformity or not.
It says not a contraindication for the job.
But as per our guidelines, it was.
Your guideline doesn't specify that.
Lordship, skin disease is there, Lordship, and this is
Skin disease is a omnibus term. It includes many conditions. Which of these are acceptable? Which of these are not acceptable?
That's
Tomorrow, if somebody has a rash on the screen, you may say that this is a skin disease. Then there must be some valid ground for rejecting it. What kind of rejection is this done by are they qualified to be doctors?
Lordship, they are
Then why are they giving such reports? It is their reference to the head of the department, dermatology. This is by the Review Medical Board.
Lordship.
Now, once the opinion is given, where is their finding? What is to be done with this opinion? Have they given any finding?
Lordship, that in the present it extensive and widespread, so it is not. That is our Lordship.
After you have returned a finding, you have referred it to GMC.
Lordship.
GMC has returned a finding.
Lordship.
You see, it is not the patient who is gone. It's not the petitioner who is gone. You have referred him. So once the opinion is given, how have you correlated it? You've not done anything. Yes. You have asked for an opinion. Once the opinion is rendered,
Thereafter, this rejections was there, Lordship.
How can it be? They must come to a finding that the opinion is same, or you see the opinion, if you read, it is not a contraindication for the job. Means the condition is not going to be a hardship for the person.
Only thing, Lordship, it is treatable written, that's why, when it is treatable,
There are
Lordship.
treatable means it can be treatable with reference to the condition.
Not sure.
Whether the condition is a disease or a deformity, that finding that your doctors have not given a finding, your guidelines also do not return a finding. Hmm.
Not sure.
And again, this is an OPD. What is your condition? You have to, it has to be analyzed, treated properly.
It is actually, your lordship, this is after doing all such examination, your lordship, they have sent it to the Guwahati Medical College, your lordship, and thereafter the Guwahati Medical College has been given this.
It's an OPD. What tests were done to
The test,
indicate?
your lordship, that is in case 175, your lordship, of the affidavit in opposition. On 75, 76, and 76. 175 of the affidavit in opposition. 76, 77, 78. This was because he is unfitted for two conditions, lordship. This was for the second one, lordship. That
Not sufficient to refer for review medical.
Herein, your lordship, the cause for which your lordship,
Hmm?
the cause for which the candidature of the petitioner has been rejected, that has not even mentioned in the,
Mention page 43.
Yes.
no, that has not even mentioned in the guideline, your lordship. But if your lordship will go by what my friend, your lordship, referred herein, in
You
3A,
show us the meaning of this term. What is the meaning of this term?
which one?
Tenia versicolor.
Tenia versicolor, your lordship, I have,
Skinned it.
it is a disease, your lordship, which may cause for the,
Disease. Disease or not a disease?
Yes.
but what I found from the Google, your lordship, I'm only saying that, your lordship. But it may cause for the deficiency of the vitamins, your lordship.
Is it a disease or a deformity? Or a medical or no? You see, you may have a disease. You may otherwise be
Yes,
a normal person, but if
yes,
you
I
have a
understood,
disease,
your lordship. I understood, your lordship, but whether it is disease or deformity, your lordship asking that only. But I am saying, your lordship, from Google, your lordship, I have searched it and found it that it can be for the deficiency of the vitamin B12 only.
Google is
And-
not an authority. You have to do your research from other reliable books or commentaries.
I have searched it, your lordship, and whether it is disease or deformity, your lordship, that is also not in here.
Then how do we find it? This is for you to explain to us.
But what is found from the Google, your lordship, I am reading this, that, your lordship. In people with the Tenia versicolor, the fungus that usually lives on the skin surface grows out of control.
Fungal infection.
Yes, fungal infection, your lordship, yes. But in others one, your lordship, I found that this may cause for the deficiency of the vitamins, your lordship, and more particularly for vitamin B.
You can't settle the BSF to give you regular supply of vitamin D.
But overall, your lordship, my submission was that
the purpose is to find that you are medically fit.
yes. But overall, my submission is that, your lordship, the medical expert, your lordship, nowhere they have mentioned that the deformity for which his candidature has been rejected, it has a force of extreme, force of spreading nature, your lordship. That has not been mentioned, your lordship.
Need not.
So,
you have to be free of medical conditions or physical defects or infirmity. That would lead to loss of manners. That is the aims of the.
yes.
So essentially, you must be medically fit.
But in the recommendation of your lordship, that in the last part, it has given that it has it will not cause any effect regarding.
No, it may not cause effect, but does it make you medically fit? You must be treated, you must be understood to be medically fit.
But the second part of the opinion,
Let us say,
whatever given in their, your lordship, from
common-
that, your lordship, we can presume
Common
that
example, let us say that your normal blood pressure should be 120 by 80. Someone has 122 by 80 or 122 by 81 or 82. Does it make the person medically unfit? Probably not. But if it is 130 by 80 or something, then may not be on that particular day when the check was done. So these are all medical terms which on that particular day, what the tests reveal would be your condition. Now, if you are suffering from a disease on the day of the test, you are not medically fit. Subsequently, by treatment, you have recovered. Cannot be a ground. On the day when the test is conducted, are you medically fit? Let us say somebody suffers from jaundice. You don't know. You go there, do the test. You are given a medical treatment and you found that you are suffering from jaundice. Of course, with regular treatment, you will be medically fit subsequently later. But on that particular day, can you say that you are medically fit? No. You will have to be rejected. Whereas further treatment will ensure that you will get back to normalcy. But that is what the guidelines say.
The guideline talks about the chronic ischemic disease.
And fungal infection is.
The grass only talks about in page 80. Page 80, there are 19. But only talks about the chronic disease here, Lordship.
Thereafter, Lordship.
Yes. But it is not chronic ischemic disease.
Chronic
It is chronic
extensive
disease.
fungal,
It is a chronic disease.
yes. Extensive fungal dermatitis also there. Fungal is Lordship.
Okay.
But it is not mentioned therein that it is the chronic.
It may not be mentioned, but if it is a disease, it is a disease. You are not medically fit.
There are one more petitioner in this matter, in this case, Lordship. Here, his case is rejected on the ground of.
There are two petitioners.
Yes.
The two petitioners, Your Lordship, the first one, I think.
First one is Noor Amin Khan.
Lordship, he failed to secure the cutoff mark, Your Lordship. Therefore, on the day, Your Lordship, made a prayer, Your Lordship, for not raising his. Hospital.
Someone did not get recorded here. Which date was the order passed? It's not here. This is not here.
Let me check out.
That may not be in there, Your Lordship.
Okay, who did not?
Petition number 1, Your Lordship.
Noor Amin.
Noor Amin Khan.
Just make a note of it. Noor Amin Khan, petitioner 1, failed to secure the qualifying marks. Therefore, in any case, he would not be called for medical. Therefore, in any case, he would not be considered for further selection. Therefore, petitioner number 1 does not wish to pursue the writ petition any further. Writ petition will be pursued only by petitioner number 2, Mozamil Haq. Okay, we'll pass orders here.
Hello. Lordship, keeping the records.
Yes, record.
I think 17.
17, my lords, the DME found certain shortcomings. Then RME was conducted. Review. Review, my lord. It found vitiligo, my lords. Suggestive of vitiligo, not a final finding. Suggestive of vitiligo.
Disposed.
Oh, let me.
24.
24 is similar to 16. Yes,
16.
yes, Lordship.
No, lordship, some differences here. In code, item number 24, lordship, the disease is lordship at page 69. This is the epirosis fistula.
It is also fungal infection.
Yes. Lordship, before that, I'd like to point out one thing. The guideline says the medical guidelines regarding skin diseases. It uses the word chronic disease. It should be chronic. Acute disease, it's not mentioned. So acute is treatable as per the lordship Oxford Dictionary, lordship. It says an acute disease is a medical condition that has a rapid onset, develops suddenly, is often severe and typically for a brief period. That is acute. And lordship, whereas the chronic, as per the Oxford Learner's Dictionary, lordship, whereas chronic diseases last for a long time and difficult to cure. So the guideline categorically stated that it should be chronic disease. Now, lordship, I'll come to my case. Yeah. In the affidavit filed by the lordship respondent, page 63 is the initial rejection. Page 63. Here, for two grounds, I was rejected initially. White spot on body, shoulders, and secondly, hypertension. Subsequently, hypertension, they have cleared me. So I was left with only white spot. So in detailed medical board, both were detected. Then they sent me for lordship the review medical. And when the medical authorities sent for review, that should also actually look into lordship. Lordship may come to the guideline at page 66. This is the guideline when review medical is to be board is to be conducted. The relevant is at page 67 plus D. Clause D says, may I read it? Clause D says, review medical board may obtain opinion of concerned specialists or super specialist of government medical college and hospital in case of any doubt. So, lordship, when there is doubt with the review medical board, when they come out with some doubt, then they forward the candidate along with accompanied by their force personnel. In my case also, I was accompanied by force personnel and was sent to Guwahati Medical College and Hospital to get the expert's opinion. Then when the expert gives the opinion, here the dermatologist, then they will have to, lordship have put that question in item number 16, then they will have to again verify it before saying on what ground they are saying that it is not, the opinion cannot be accepted, specialist opinion. There is no mention of such thing. There, the guideline itself says when there is doubt, they have come to a doubt, so they have forwarded me to a specialist for a specialist opinion. So now my specialist opinion says, yes, it is treatable, but it never it is reflects that it's an acute disease. My one is, lordship, in Assamese we say it sum porabu. So white spots, sum porise in my arms. So it has cured, and it is said you only it said it is treatable in the disease, and treatment can be given for 2 weeks only. So it's an acute disease, lordship. Guidelines never said that it's an acute disease can be rejected in skin cases, lordship. Page 16 of medical, lordship. GMC's opinion, lordship.
69 is.
Sorry, 69, lordship.
Opinion.
69.
Yes, their
69.
opinion is.
This is the
treatable.
specialist, senior resident dermatologist specialist. This one. So doubt was arisen in them. So they have just recommended my case, accompanied by the force officials to the specialist.
Now specialist says, Lordship, may I read?
Hmm.
This is the original one. Patient is having pityriasis versicolor. This is the sum over his trunk and both the shoulders. It is a treatable condition. Treatment is given for duration of 2 weeks. He is fit for perform his physical duties. So any eczema or something, it's like that only. It's a fungal disease. So guidelines says fungal disease is there, okay, but it should be chronic. So let's see, in that count, after opinion or getting the opinion, now in the affidavit at paragraph 11, this is not paragraph 11, it is let's say paragraph 9. Let's say may come at paragraph 9, page 53. Let's may directly come to page 54, penultimate paragraph. Page 54, penultimate paragraph. May I read, Lordship?
Yes.
Page 54, penultimate paragraph. It starts with the word further. May I read, Lordship? Further, it is submitted that the echocardiography test of petitioner was conducted at Narayana Super Specialty Hospital. For the hypertension, he was forwarded to Narayana, and for the skin disease, GMC. Guwahati by Dr. Dipankar Majumdar, Associate Consultant Cardiology. Opinion of Senior Resident, Department of Dermatology and STD, Guwahati Medical College, Guwahati was obtained regarding white patches. Now it's important, Lordship. On the basis of specialist opinion, the review medical board also found it. How they have found it on the basis of the GMC doctor, they said it's treatable for 2 weeks only. Now, from where they have come to this conclusion that they have also found on the basis of this?
Treatment was not given. In the motto is not to give the treatment, Lordship. It is if there is a disease, then has been rejected, Lordship.
No, that disease is that should be chronic in case of skin disease. So it is they are saying on the basis of specialist opinion, the review medical board also found it unfit.
Fungus.
They have not carried out any examination. Because of they didn't have got that expertise, so they have forwarded me to the opinion to get the opinion of the specialist. Then what is the use of forwarding to the specialist? Not if they're just coming to that only conclusion.
What is the guideline saying?
Guidelines say that page 7.
Page 7.
Page 7.
Fungal dermatitis.
19. Clause 19.
Clause 19.
Page 7.
Page
Yes.
7 of the guideline.
Clause 19. General grounds for rejection.
Is it available here, guideline?
Yes, Lordship. Page 7.
No. Is it in the part of the pleadings? No. All right, page 7.
Yes, Lordship.
Hmm.
Internet page 7.
Hmm.
Clause 96. Paragraph 6. Clause 19. It says chronic skin disease like vitiligo, leprosy, SLE, eczema. Eczema is also, they are saying chronic, it should be chronic. Eczema, chronic extensive fungal dermatitis.
Chronic
Yes.
extensive fungal dermatitis.
Yes.
Chronic it is.
But it is in the petitioner's case, it's not chronic. Eczema also, for eczema also it should be chronic.
What is your condition?
The last one, chronic extensive fungal dermatitis. But the word here is that is not here mentioned in the guideline properly, but word is it's a fungal disease at page 69. Page 69 of the affidavit. It is called pityriasis discolor. This is a fungal disease, fungal skin disease. If it comes under this also heading also chronic fungal disease, then also it should be chronic.
Yes.
And Lordship comes to page 81 also of the affidavit. The reason for getting the opinion, because they don't have got experts, so they get the opinion. The opinion for recruitment. This is the reason why they send. petitioner didn't go by himself,
All right,
Lordship.
dispose.
Oblige, Lordship.
And then.
This is item number 24.
24, Lordship.
Yes,
Oblige, Lordship.
25.
25.
Wait, Lordship. This is the similar case.
Hmm.
The name of the disease is
May I please, Lordship?
pityriasis versicolor. Yeah.
This is here, this petition is suffers from territorial jurisdiction, Lordship.
Oh.
Kindly come to pay the advertisement, Lordship. Page 40 of the writ petition.
40, 40.
Yes, Lordship. Clause number 18. Court's jurisdiction. May I read, Lordship? Any dispute in regard to this recruitment will be subject to courts having jurisdiction over the place of regional office concerned of the commission where the candidate has appeared for the computer-based examination. And in this petition, he appeared in for computer-based examination on at Bihar, Lordship. Page 48, come to the page 48 of the petition. This is admit card for his computer-based examination, Lordship. Here, Muzaffarpur, Bihar. Pariksha Kendra, examination venue.
Where is the venue written?
Below the photograph, Lordship.
Exam-
Examination venue.
Yes. What do you say?
Lordship, in this regard, I am relying on two judgments of two different high court.
Hmm. Why did you appear in, where you are a resident of Assam?
Yes, Lordship.
Then why did you appear there?
Lordship, three choices were given and he was placed there, Lordship. Just going to appear.
Yes.
2007 Zero Supreme Odisha 191.
Hmm.
Para 6 and 7. May I read?
Yes.
We have reduced the advertisement annexer 1 clause 8.1 of the advertisement reads as follows. Any resultant dispute arising out of this advertisement shall be subject to sole jurisdiction of the courts situated at Mumbai. Undoubtedly, the above clause is part of the advertisement. However, in order to determine the territorial jurisdiction, it is also seen whether any part of the cause of action has arisen within the state of Odisha. Cause of action has been defined in Mulla's Code of Civil Procedure. The cause of action means every fact, if reversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. Right to invoke jurisdiction under Article 226 of the Constitution of India to enforce fundamental rights and other legal rights against the state or authority or its agency is a constitutional right. Such right should not be made illusory or unenforceable upon narrow construction of the concept of cause of action. In the present case, the advertisement was published.
Yes, all right. Jurisdiction will not be a point here. You can't exclude the jurisdiction by an agreement.
But our advertisement, it is clearly mentioned.
Maybe, but
Yes, Lordship.
can it curtail the jurisdiction of the court by way of an advertisement?
Yeah.
Yeah.
Yes.
Your Lordship, petitioner on the date of interview, petitioner, some white spots was found in the neck and chest of the petitioner. So
Where is that
on the-
report?
at page 49.
49.
It's at page 50, actually. May I see point number 1, severe hypopigmentation in bracket pityriasis versicolor on whole body.
This is the same ground,
Same ground.
ground.
It was on
same ground.
3/10/2024. The next page, page 51, it is the review medical board report. It was done on the next day, as per rule also. But what happens also in this case, the white marks of the petitioner got disappeared after 7 days. And now he is absolutely fine.
That is irrelevant.
Yes, Lordship.
On the day when you had exposed yourself to medical test,
Yes, but Lordship, that is what the medical board should come
but the
to a
condition
conclusion
is
that
the
this is a
same as the
chronic
earlier
disease.
one.
Yes, Lordship.
All right, we'll pass all this.
Medical board should come to the conclusion that it is a chronic disease. And if it disappears in 7 days, then this is not a chronic disease. Lordship.
But here,
And even
Lordship,
today, if your Lordship directs, then he can appear before the medical board.
here one thing is the record is on Muzaffarpur, Bihar, Lordship.
It's not come.
RME. I am not Lord. RME was conducted there, Lordship. All his DME also there conducted there at Muzaffarpur, Bihar, and RME also.
Where did you apply from?
From Guwahati. It is an online application also.
Hmm.
Here, page 15,
Is a state of
it is
Hosai.
here clearly mentioned the venue.
What are the options you had given?
Varanasi, Patna, and Muzaffarpur.
And
He was not in Assam also. I accept that also. But he is from Hosai. His residence is at Hosai also.
Residence maybe was
And
but the
this- the
whole
office of-
procedure is
His
conducted
office of regional is
Bihar,
at
Lordship.
Guwahati.
computer based examination, PST, PET, RME, all are.
there are judgments of this court also on jurisdiction. If you want, you come and place it day after tomorrow. We are keeping it open
Yes, Lordship.
day after tomorrow. This is
Okay.
item number 25.
Hi.
Rest of the members of the series from 16 to 40.
Item 21.
Yes.
SSR.
What are the grounds?
Lordship, hypertension.
As convicted counsel is on lakes on another court.
No, in cause list, my learned friend's name has been shown probably. Yes, who was the 21.
Hypertension is a ground of rejection.
Yes, Lordship.
I-
They say that it's a ground of rejection, and in fact, in their guidelines, as per their guidelines, it's 7E. It says that an X-ray as well as echocardiography has to be done. In my case, they conducted the echocardiography, but not conducted the X-ray. Whereas the guidelines also says that on not only the X-ray and echocardiography, ECG, serum creatinine test, lipid profile test has to be conducted. And that is not done. In fact, there is a difference of opinion of the review medical board and the general surgeon opinion, which they sought it from the Guwahati Medical College. And since there is a doubt created, raised by their own reports, so as per 6(4), it has to be referred to referred to a government medical college or a specialist of the concerned field. And in fact, my review medical report that nowhere says that any of the members were specialists of a concerned field.
He was admitted in GMC for 3 days, Lordship. Record is
Recorded, your lordship will find page 79 is the rejection report. 79 of my petition. 77 is the type copy. The ground of rejection in the detailed medical examination is grade 3 external hemorrhoids and raised BP 158/100, 148
by 96. And thereafter he was referred for review medical examination. In review medical examination, has your lordship got?
79.
79 is not so legible, but if your lordship can refer 77.
Yes.
The serial number 2, brief of review medical examination and finding thereof. General surgeon opinion attached. Patient is clinically fit from surgeon's side. Candidate was admitted for 3 days in Composite Hospital, Guwahati for BP monitoring. 3 days BP monitoring reveals diastolic hypertensive, 2D echo, mild amber, RVSP 27 plus DAD. So DAD is diffuse alveolar damage. And final opinion, your lordship will find unfit on account of diastolic hypertension, trivial regurgitation, and pulmonary artery hypertension. Now, your lordship may kindly see page number 95 for a moment. Page
Where
90.
is this is not the review. Is this the review medical?
No, 77 is the report of the review medical.
Review medical.
Yes.
Review medical was conducted.
Yes.
CT
Page
scan.
95, I'm just pointing out, your lordship.
95.
95. 95 is the guidelines of the respondents. Because the review medical report, it says that
There was we had disposed of one matter
Yes,
on
Lordship.
hypertension. Or
But
yes,
do you have that order?
lordship, I do not have the order because on last occasion when I referred that particular order, the lordship had asked me that whether that includes pulmonary artery hypertension.
but here is
So the guideline
different. Lordship.
7E, no, because of pulmonary artery hypertension, the guidelines nowhere differentiates pulmonary artery hypertension. Guidelines say that once there is hypertension is found by the respondent, they have to conduct an X-ray as well as ECG report.
Yes, CT scan also done, Lordship.
No, CT scan is done. I am not saying that they have not done ECG. Because if I may refer 6D for a moment, 6D specifically says their guidelines. Review medical board may obtain opinion of concerned specialist or super specialist of government medical college or hospital in case of any doubt. Now, if your lordship peruses page number 77.
Do you have the number of that order? The case number or the date? Give us.
That's it.
What's on it?
7/24.
Give it to the court master, they'll take a printout. Yes.
Order also I have.
5987.
But here kindly our
May I
record,
humbly
Lordship.
place, lordship? Because 6D, since it says that when there is a doubt raised, they have to take an opinion of the super specialist. Now that doubt, if your lordship peruses page number 77 again, that doubt arises.
You're referring to the
Guidelines. Yes.
7E.
6D.
6D.
Review medical board may obtain an opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Now that doubt arises in view of the report of the general surgeon's opinion, because general surgeon opinion, while rejecting my review medical, a general surgeon said that I am clinically fit. So the moment there is a difference of opinion of the general surgeon, which I was referred to by the respondents, so they have to seek an opinion of the specialist. That is not absolutely not there in the review medical. So once there is a difference of report by the doctor to whom I was referred by the respondents. So, and thereafter they say that as per the 2D echo, 2D ECG report, I am not fit. And the general surgeon opinion says that I am fit. So they have to seek an opinion from the specialist of the concerned field. Now, if your lordship peruses page number 77 and 78, the review medical examination report, it nowhere says that I was referred to, after the general surgeon's opinion, I was referred to a specialist. That is one point. And secondly, 7E is not followed. In fact, in my writ petition, I have made a categorical statement that 7E was not followed. In their affidavit in opposition, they have not denied it. There is no specific avowment that they followed 7E.
But as per our ECG and CT scan report, it is their mild MR.
Why is a reference to a super specialist required?
Because, Lordship, their own guideline mandates it.
If any doubt is
Yes.
doubt,
That doubt,
if-
now if your Lordship peruses page number 77 for a moment, that doubt is there because a general surgeon, before whom I was referred by the respondents, he has given an opinion that I am clinically fit. And therefore, when the surgeon's report is there,
Surgeon is not the qualified person.
no, that is therefore, Lordship, the review medical board has to seek an opinion of the concerned person.
No, you were
of the
referred
concerned
before,
field.
you were referred by whom?
By the respondents.
Where is that report?
Lordship, that report is on with them. But at page 76, I have annexed the report. I have somehow collected it.
quanti-medical.
Yes.
FSB, PPBS is lipid profile.
Yes, everything was done. And it says clinically fit at the time of examination.
This is only so far as the advice slip is concerned.
Yes, Lordship.
As an OPD patient,
Yes.
who referred you there?
No, the respondents
Where?
to GMCH
No.
on 1710.
Is there any forwarding letter, etc.?
No, but all the candidates, most of the candidates, they were taken to GMCH by the respondent CRPF. Group Center, Amerigo. They had taken them to GMCH. In fact, they have their reports on the record.
Where are the reports? Please check the reports.
It will be medical. Tapisot. Yes, they in their report also, Lordship.
Yes, it is there, Lordship.
GMC report.
But A2.
No, A2 no. A2 report GMC.
What report?
A2 report GMC. Did you?
Why are you not bringing these on affidavits? You have filed your affidavits. Is there any reference? Where is the
No, letter is not there, but that report of GMCH hospitals doctors is there, Lordship.
where is the where are the test reports?
Test reports on their test reports are there, Lordship.
No, for test reports for the GMC from the GMCH.
That test reports from GMCH not there, but some CT scan and enlisted one enlisted diagnosis
These are
center,
done-
Suraksha Diagnosis Center.
These are done by you.
Yes.
At a
Yes,
private,
that are done by.
at a private. These are done by the composite hospital.
Yes, Lordship.
If the composite hospital does not have these facilities in-house.
In some tests are held by them, but conducted by them. But some tests for some tests they are sent to.
No, what sometimes these are mere X-ray reports and blood reports and all that. heart is not available in the hospital. There's echocardiography. There, it is supposed to be conducted by the composite hospital.
Echocardiography may be conducted at CRPF Lordship, composite hospital. And he was admitted for 3 days and pressure monitoring the blood pressure.
No,
also.
it is shown to be done by the Suraksha Diagnostics.
That is maybe CT scan and X-ray.
Their own guideline specifically mandates for respondents, Lordship, that once you examine someone in respect of blood pressure or hypertension, you have to make it very specific in the report that whether it was transient in nature or non-transient.
Where do you get all that?
That in their own opinion, 95, page
Where?
95, page 95.
95.
Yes,
Where?
it is their guideline. 7E for a moment, Your Lordship, may kindly see. May I read 7E, Lordship? For candidates who have been rejected on the ground of hypertension / tachycardia should be admitted hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is due to any organic disease. In all such cases, X-ray and electrocardiographic examinations of heart and blood examinations like cholesterol, lipid profile, serum creatinine, and other tests should be carried out.
That tests are carried out right.
But there has to be a finding.
That tests are done by this.
The test says that I'm clinically fit.
And this is example, X for example.
The examples are prescribed because they make mistakes. And that is why these examples are prescribed for the respondents.
X-ray.
And it is their own example.
X-ray already done, CT scan also done. Of course.
Review medical report nowhere says that, nowhere reflects that whether that rise of blood pressure or hypertension was because of any transient in nature or it was because of some other reason.
What was the finding in this judgment of Kaushik Paul?
Kaushik Paul judgment is review medical board's decision is.
Oh, that is the finding of the, there is a ground for dismissal. What was the finding of the High Court?
1.2. Oh.
The finding of the High Court.
High Court was it to see. Has to High Court was it.
The High Court, Lordship, it's a
Hmm.
judgment of Calcutta High Court.
Yes.
It says the prayer in the writ petition was inter alia for quashing Annexure P8 and P11 being the medical report and report of review medical board of respondents, whereby concurrent finding was appellant has visual acuity in both eyes. It is regarding eyesight. At 6/9, we find said certificate dated 5th March 2021 certifies visual equity in both eyes at 6/7.5. Hence, we quash reports being Annexure P8 and P11 in the writ petition. Respondents are directed to consider said certificate dated 5th March 2021 regarding appellant's candidature. In event appellant is appointed or recruited, well and good. If appellant is found on said certificate dated 5th March 2021 to be disqualified for appointment or selection, the basis of disqualification should be made known to him. This is the finding of the High Court, Lordship. It's a division bench judgment.
Hmm.
The appeal is allowed to the extent above and disposed of. So that case was particularly with respect to eyesight.
Also rejected on review medical board. Yeah. Outside drugs.
Do you have a copy of the judgment? Let us go through it.
No, Lordship.
Give the reference, we'll take a copy.
Lordship.
You will take it up day after?
Lordship.
Yes. This is item number
21, Lordship.
21. All right.
In respect of item number 37, Lordship,
Hmm.
the respondents are yet to file their affidavit in opposition. They have not filed it.
37.
Yes, because they are finding it difficulty to file it because if your Lordship perishes for a moment, 37. Why there is a difficulty on the part of the respondent to file it?
Kindly fix it on 11, Lordship. 11.
Because they rejected me on a note. They first get a printed computerized report and then they deleted it and then they written it a handwritten note and they rejected my candidature.
All right. But day after.
40 also day after tomorrow, Lordship.
All the other matters are all different grounds.
Yes,
So-
Lordship. Different grounds. Take it up, you can. All are different grounds. Issues are all are different. Lordship.
So I requested for making a chart for all the matters with what are the grounds for rejection?
Yes, Lordship.
Because the grievance of the petitioners are largely on the same grounds that the Review Medical Board did not consider the government hospital or the private hospital
Yes.
or report, or the finding does not reflect whether it would hamper wearing of competized uniform. That is the common ground.
Yes.
We prepare a chart and give it to us.
Yes,
We
that's it.
complete all the matters, except for those matters which have already disposed of. Rest of the matters we
Yes.
complete the hearing. Then we'll have it next week.
I also try to file a synopsis of or list
No,
of events.
no, we don't need a synopsis. We need a chart.
Lordship,
Item number so and so, ground of rejection so and so.
Lordship.
Yes.
Whether what is the term used, and you can give a reference of the guidelines.
Lordship.
What the guidelines is. That's all. Prepare it and get it ready on 16th or 18th. List on 18th.
Lordship.
We are giving you sufficient time.
Lordship. Item number, starting from item number 21, Lordship. Yes. Much of.
You can include all the matters.
Yes,
These matters we have already heard. Rest
Yes.
of the matters we can close the hearing then.
Lordship. Much obliged.
Yes.
Substitute for long.
Item 41.
Hello, very good. Yes. Item
Yeah, my lord, we have put
41.
to challenge the, my lord, the removal order of the petitioner, my lord.
All right, we'll day after tomorrow.
Lordship, next week, Tuesday.
No.
So can it be on Tuesday, my lord? Because even I have some difficulty. Lordship, I recorded this last chance, my lord.
But Tuesday, we already have a lot of matters. Therefore,
Thursday, my lord.
Thursday, we have fixed this series.
This Thursday, my lord, I have some serious difficulty.
You are appearing, you are representing a matter of 2013.
Yes, my lord. Let it be on Monday then, my lord. On Monday,
All right, Monday.
yes, my lord. Obliged.
Monday. As agreed to by both councils.
Items 42 to 45.
Yes.
Lordship, in these matters, Lordship, contention was raised on the previous occasion that the petitioners have not received their MSCP benefits. Lordship, in this connection, I have written to the authorities, but there are 113 petitioners. It's difficult for me to get the information at a single go. If my friend can point out who has not received the MSCP, I can do the needful, Lordship.
Has anyone received or yet to
Because
receive?
last time there was a statement made that they have not received. But
They have not received Lordship.
if all have not received Lordship, that's one thing.
Basically, they are concerned with the grade pay of 2,400 Lordship. That Lordship has not been granted.
Have you filed any counter
We
affidavit?
have filed a affidavit. Now, the case of the petitioners is, Lordship, that the SKT, that is storekeeper technical, their pay has to be fixed at in equivalence with storekeepers in other organizations, which we have controverted, saying that, Lordship, storekeepers here, they have got the qualification, entering qualification of class 12 pass. While in other organizations, there are some technical qualifications as well. Therefore, we differentiate it. But now, Lordship, this matter has gone beyond that. Now they have, by way of an additional affidavit, they have sought for something else. So that instruction, Lordship, I have to take, Lordship.
There is some judgment that is referred here. I do not know of this court. Vishwakarma. In the affidavit. Page 8.
Lordship, in that judgment, basically the contention was with regard to their qualification, Lordship. They were diploma holders and they claimed the pay scale given to the degree holders, Lordship. So that was granted.
No, what instructions are you awaiting?
May I just explain, Milord?
Ah.
Milord, what happened actually, although the writ petition has been filed initially way back in the year 2013, praying for higher grade pay on the ground of parity. In between, Milord, lots of development took place, like 6 CPC, Milord merged 2 cadres of this particular category. And by virtue of those merger, the next post pay has been upgraded. Pay of the grade pay of the next post, promoted post were upgraded. Milord, those benefits were not given to the present petitioners. By virtue of that, they are still languishing in grade pay of 2400, whereas
Lower post.
Milord, post is all right, but the pay grade, because by virtue of the merger, the feeder post, 2 posts were merged, and initially it was 1800, then it was merged, 2 posts merged and given 1900. Correspondingly, the promoted post pay also upgraded. So by virtue of that upgradation process, we are entitled to 4200, but we are given 2400. That is one aspect. Apart from that, Milord, MACP benefit were not given to the petitioner. So these facts come during the pendency of the writ petition. So I have filed a affidavit reply in detail, incorporating everything. Perhaps that my senior has to take instructions on that affidavit, Milord. That is what my senior is pointing out.
Yes, that is one part of it. In fact, on the last occasion, my learned friend's plea was that they were not given the benefits of the MACP. And if they get the benefits of MACP, maybe their grievances would be redressed. It was only on that premise that I was asked to take some instructions. Now, if he says that there are 4 writ petitions out here, 113 petitioners are there. If 113 writ petitioners have not got their MACP or ACP, whatever be, that is one case. I can take instructions on that. But 113, Lordship, I have to collect the information from different sources. I'll need some time. But if it is a case that few of them have not received, he can point it out. That would be easier for me. But now he says that nobody has got.
No one has got it.
That's my instruction.
So I would be requiring some time for that, Lordship.
Otherwise, also I also understand that so far as my affidavit reply is concerned, my senior is
So
required
that
to take instruction, but because without their response, perhaps he'll have to file a response also. Because without their response, my lord, the hearing will not be, I don't think.
No, I will,
So that's
Why don't you go for mediation?
that
No,
can also be
this
done if,
process.
Sort it out. If it doesn't work out, you come back. 2014 matter, you're still in the process of filing affidavits.
Correct.
Lordship can.
One
we-
affidavit
we-
has been filed, but because of the subsequent developments, my lord, in between developments, this has come out. I
How
don't
much
think-
time are you praying for?
Lordship, let it be immediately after the vacation, Lordship. Because we have prepared a format and said, have sent it across. There are 113 petitioners, Lordship, in all. यहाँ तो कुम्भ तो ऑफिसर तो multiply पर चांस था दोनों क्यों? हाँ, मजा ना जुड़ी पाए. Technically.
Yes.
No, I was just talking to my friend regarding sending it to the mediation. Lordship, since it is a technical matter, maybe the officers would not understand. Or
Matters be listed immediately after vacation on a date to be fixed by the registry. As submitted by the council for the parties. It is submitted that the status of the benefits claimed by the petitioners are required to be instructions with regard to status of the benefits, if any, received by the petitioners are required to be obtained in the meantime. Accordingly, list again.
Lordship.
Much obliged.
Yes. What are your claims here?
May I submit, my lord? If your lordship kindly takes up the order dated 25/2025, my lord, of this honorable court.
Hmm. Yes.
Here, my lord, in the third paragraph, the challenge made by the petitioner is mainly against his removal from the service from the post of so-and-so. But having regard to the claim made about the medical reimbursement dues as well as the arrears salaries, the petitioner is given liberty to file an additional affidavit precisely stating what according to him is due to be paid by the respondent authorities, which may include the medical reimbursement bills as well as the arrears salaries. Such claims should also contain the specific details as far as practicable, so that a response can be heard from the respondent authorities. So in pursuance thereto, my lord, he has filed the affidavit at page 1797. Here, my lord, no specific details is given, my lord, except the copy of the representation at page 1800. I think, my lord, it will be outside because it's a small affidavit. My lord. It will not be there in the bound copies, my lord.
Affidavit? Any
Affidavit
affidavit
separate.
filed?
There is a
Any affidavit?
at the causeless step. There is a separate file for the affidavit.
Separate file.
Headway.
Flag L. Flag L, Maharaj. Flag L. Hello. Correct.
Lordship has got the affidavit. Page 1800 is a representation submitted by the petitioner. There he gives the details, my lord, towards the bottom, my lord. In light of the above, I hereby write this letter for immediate release of my outstanding medical bills along with relevant details for the period from June 2020 to August 21 as detailed in pages so and so to so and so of my affidavit. Now, my lord, in response,
Which page you are reading?
page 1800. Oh, 1806. Sorry.
1806
Of the, because it is numbered serially, my lord. There is an affidavit filed by the petitioner starting at 1797.
No, affidavit filed on 18th August.
No, 27/6.
Oh. What was the last affidavit you filed? Which date?
Yes, Lordship. Can you allow me to submit a little bit more details, Lordship? Can you refer to the order dated 27/03/2025? Lordship, in that order, this honorable court, in the last paragraph, the Learned Standing Council for the NRL will furnish the details and oblique particulars of the payment made to the writ petitioner by email by the next date of listing. These amount are which the petitioner in person claim to be entitled in his representation dated 06/02/2025, addressed to NRL. Was it this representation just the Learned Council of Respondent number 2 marked referred to this honorable court at page number 1806. This honorable court ordered that Learned Council of Respondent number 2 will give the details and particular with reference to the representation given by me on 06/02/2025 by the next date of listing. And accordingly, the matter was deferred to list the matter three weeks. Lordship, this order was given on 2703. So they were supposed to submit the details on 1904 2025, but they failed to submit any details. Subsequently, my case was listed on 2005 2025. Prior to that only, that day also, on 1905 2025, they failed to submit anything. On that 2005 2025, when my case was appearing in this honorable court in the first half, one of the counsel from the response number 2-3 said that the learned counsel was busy somewhere in other court, so they tried to pass over the matter. Then I addressed to this honorable court that there is a continuous violation of this court honorable court order since 2023 September 2023. This honorable court in various occasions, numerous occasions, there is an order that they were instructed to even examine my claims, but they randomly submit in this honorable court. There is no any dues pending from their end. This 2025 the order of this honorable court is completely based upon some misleading and false statement. Lordship, kindly refer to the order dated 2005 2025. Mr. N. Dekar, learned counsel for response number 2-3, on the other hand, submit that as per the instruction he has received, there are no dues which remain to be paid to the petitioner, and he submit that he has been given the details of the payment made to the petitioner by the assistant manager HR and payroll. Lordship, in prior to the order dated 27/03/25, where this honorable court ordered to give me the details and particular with reference to the representation that's on 06/02/2005. Against this representation, there is no any details given by the learned counsel, neither prior to the date of listing nor on that hearing day. Just during the ongoing hearing, he submitted a pieces of document which he claimed to be received on prior to the date, but he did not submit it over mail. As well as the document, he claimed that it is a mail copy, but it is a Word document. The document is found to be a fake document. Because after that, I asking for authentication for them, but they failed to give any particular details and document. And that document was submitted just to misguide this honorable court and pass this order. Because this honorable court earlier give the order for details and particular. They just try to avoid to give the details and particular. That is why they created this kind of anomaly. Reason for which, with reference to my claim for last 2 years, what was happening, I had made it after that on Lordship on 29/07/2025. I specifically request this honorable court to allow me to submit all the details with respect to my claims. Accordingly, this honorable court allow me to file an affidavit on 18/05, against which the respondent is supposed to file a reply before 5 days from today. But they failed anything. But I already submitted an affidavit on 18/05/2025, where I have made all the details also with reference to my claim, what they gave random as well as false statement. Earlier they apprised to this honorable court there is no any due. But when this honorable court on 27/03/2025 ordered to give the details and particular, they suddenly come with a pieces of document, though this is found to be a fake document, that there is a pending due. But last 2 years they continuously apprised to this honorable court there is no any due. And now when I subsequently file an affidavit, then they apprised to this honorable by submitting an affidavit that they could not locate my pending claim, some of my pending claim, and whatever they have submitted in this honorable court by affidavit dated 24/07/25. All the statements are found to be false, Lordship, just to misguide this honorable court. Against which I have submitted along with all the details in my affidavit dated 18/05/2025. 08 2025, Lordship. If this honorable court allow me, then I can read my submission, Lordship.
What are you challenging in the writ petition?
Writ petition, Lordship, I challenge
Where is your writ petition?
in volume, Lordship, 1, Lordship.
Volume 1.
In the writ petition, Lordship, I had not only challenged the order of the removal as well as all the related document, but I also submitted prayer to this honorable court that pending disposal of this writ
You
petition.
were working in the NRL.
Yes,
What capacity?
as a manager marketing, Lordship.
Manager. Then what happened?
Lordship,
Why were you removed from service?
Lordship, there is a transfer order. In the transfer order, it was specifically mentioned that I have to join in the new location within a period of 2 months. But prior to that, the respondent number 6, who supposed to release me, he himself asked me to submit an application, Lordship, against the transfer order. And accordingly, by violating the transfer order, though at that time I did not realize that he himself violated the transfer order, but subsequently they suppressed the issue. Not only he suppressed the issue, the inquiry officer himself suppressed the issue, Lordship. But when they submitted an affidavit in this honorable court, then I come to know that they themselves violated the transfer order. And just to create an issue against me, they
The respondents are represented. Mr. Deka is appearing for
I am appearing for the
Numaligarh.
Numaligarh refinery.
Who appears for 4, 5 and 6?
Appearing for 4, 5 and 6.
4, 5 and 6. Okay. All right. Then, was there any proceeding initiated against you?
Lordship, there is just completely misrepresentation, suppression of material facts. Lordship, they did not actually clarify any issue those which are actually found to be related, which with respect to the imposed penalty order. Those issues are purely related, but they did not respond. They make a representation that those issues are not related to the issue in hand. So accordingly, I made a representation against their document, but they suddenly, without the respondent 6, without having any rank as well as position to act as a disciplinary authority, he suddenly imposed a major penalty by order as a removal from service. Though for this kind of penalty, he has to be in the rank as designation of disciplinary authority, for which he did not have. Lordship,
did you file any appeal against the department?
Yes, Lordship.
The dismissal order?
Yes, Lordship, but the respondent 4, who was in the director technical as well as additional charge of managing director, he actually my appeal was supposed to be addressed by managing director of Numaligarh refinery, but in the meantime, the Numaligarh managing director was retired, so it was supposed to be sent to the higher authority, but it was hold. I don't know what is the reason they hold, but they could not provide me any document reason for holding the same. They were supposed to give me.
What happened to your appeal?
The appeal, they appeal the same penalty and continue. I place a review application also, but they did not address all the issue. And there is.
What are your grounds for seeking interference in this order?
Sorry, Lordship?
What are the grounds? What grounds do you want the dismissal order to be interfered with?
Lordship, first of all, there is when I submit the writ petition, there is a completely suppression as well as misrepresentation. So from the very beginning, Lordship, the first actually I could not actually estimated at that point that the transfer order was violated by them by respondent 6 itself, Lordship. So though I in my writ petition I mentioned right from the show cause notice, till the penalty order.
Where is the show cause notice? Page number? Page number?
Can you allow me some moment?
503. The main show cause is 503.
503.
Ultimately, my lord, I'll have to take out those documents and file a consolidated written submission. It will be very difficult because
Lordship, there are many occasions the learned courtship prior to this honorable court defined request, but he subsequently failed to submit those documents.
Please. Lordship will take up volume 3. The relevant documents Lordship will get in volume 3.
The show cause is available, volume
Yes,
2.
show cause is available. (436) that was a show cause, and then main charge sheet is 503. 436 it will be like volume.
Where is the inquiry report?
Was it volume 3?
Page 569, my lord.
You participated in the inquiry?
Yes, Lordship. There is a false allegation that I did not participate. even though the document itself proved that I participated in the proceeding.
What do the rules say? What are your rules?
Lordship, can we refer to the page, actually volume 2, from page 439, Lordship.
Yes.
There is a procedure for imposing major penalty. That is started in page 458, Lordship. Under the rule 6, there is a sub rule 18, Lordship, at page 461, Lordship.
Yes. Now, there are 2 charges against you.
Yes, sir.
You filed a reply.
Yes, sir.
Matter proceeded for inquiry. Inquiry resulted in a finding.
Yes.
Where is the infirmity?
So, as per the rule 18, if the management staff does not submit the written statement of defense, refer to the sub rule 3 or before the date specified in the purpose of does not appear in a person, then only the rule says that the procedure can be held as an ex parte. Lordship, kindly refer to
The
the
ex parte hearing.
Yes, Lordship. Actually, there is a suppression of material fact, there is a misrepresentation, there is a lots of fraudulent, like Lordship. They manipulate, the inquiry officer himself manipulate his own document, Lordship. Lordship, on the day of the second inquiry, Lordship.
Wait. What second inquiry?
Sorry, Lordship, second proceeding of the inquiry, second day of the proceeding, that was actually already enclosed in the inquiry report at page 576, Lordship. Lordship, in the inquiry report at page 576, serial number 4, it is mentioned that since the search officer was uncooperative and illegally that the inquiry was not legal, the inquiry officer had no other option but to continue and conclude the proceeding as ex parte, Lordship.
576.
Yes, Lordship.
Hmm.
But Lordship, though actually as per rule, as per the procedure of major penalty, though the proceeding of the inquiry should be submitted to the search officer on the day on the proceeding of the day after concluding the day sitting. They did not submit Lordship, they did not submit to day in proceeding on that particular day. They created lots of delay. Lordship, they created by creating a Lordship. They did not even the inquiry officer did not even submitted the said document to me, neither prior to submit the inquiry report. Nor in the inquiry report, Lordship, they submitted separately, which I annex in page number, Lordship, 1020. And 1021, Lordship. In 1021,
There are no management witness.
Lordship, there is a management witness, which, Lordship, actually the issue was occurred when I submitted a complaint against the respondent 6, where he repeatedly involved.
Mr. Deka, in the inquiry, there were no witnesses. Management witness,
No, it is based on documents, my lord.
only based on
It is
documents.
based on documents. Position is admitted, my lord. He was transferred.
Hmm.
He did not join.
Hmm.
That is the allegation against him, my lord.
This is a totally false allegation, Lordship.
And
It's a manipulated
he did
allegation.
not participate in the
He
inquiry.
did not participate. Lordship will kindly take up page 550. Rather than, my lord, answering to the charge sheet, my lord, he raised question as to asking us to produce evidence that the person who has issued the show cause notice, I mean the charge sheet, my lord, is his discipline authority.
So, Lordship, kindly allow him to submit in by document, Lordship, where I submit say kind of statement, Lordship. Kindly allow him to submit because for last 2 years there is lots of random as well as false submission, because reason for which by submitting my recent last affidavit, I pray to this honorable court at least to release at least my pending dues, Lordship. And prior to that, in last many occasions, the learned counsel of respondent by submitting defense issue.
But there is a witness named, page 550. There is a witness name.
No, my lord. Where, my lord?
Serial 6.
Yes, yes.
For
Just
what purpose?
let me verify, my lord.
Where is your reply to the show cause?
Lord, 1021, the witness deposed, my lord.
10.
21.
Paper book. 1021, page number.
19.8. After the hearing. Presenting officer. Regular here. This is part of what affidavit. We have a decision.
Do you have prepared an index?
Yes, Lordship.
Why you have filed so many volumes? We need to look into specific documents.
There's a
Do you have an index with you? Show cause notice, reply, inquiry findings.
That is already available in the actually repetition original.
I know it is available, page numbers
Yes, sir.
specifically. Can you prepare a list and give it to us so that we can quickly refer instead of troubling you or
Lordship,
the other council?
Actually, in the last order, Lordship, in 2005, 2025, this honorable court actually listed the matter just to actually address the pending dues, Lordship. Then whenever there is the issue raised about the pending dues, there is a effort to divert the issue to the main repetition. When there is a court order.
Is your grievance still alive? The voluminous writ petition that you filed, are you pursuing this matter or not?
Yes, Lordship.
So we are trying to go to the root of the matter instead of this due, that due. Let us understand what is the cause of troubling you and troubling you to come to the court.
Lordship,
Let us understand and decide this matter.
Lordship, kindly at least consider the pending due at least, which are pending for last 2 years, Lordship.
Pending dues are all right, but let us first understand. Supposing we hold that the inquiry is bad. Besides these pending dues, there will be other pending dues payable to you. You'll be reinstated in service.
Lordship, at least this pending, consider this. At least
These pending dues, they have denied, saying that there is no due.
No, they are submitting false statement, Lordship. That is why.
Therefore, we want to go to the root of the matter to find out.
No, Lordship. For pending dues, we need not to go to the details, Lordship. I have submitted a.
So we are proceeding for hearing of the matter, whether you like it or not. If you want to address the court on these matters, if you are not ready, we'll give you another date. Not a problem. But we are not here going through all these matters just to find out what is the pending dues. You have come to the court, you have filed this petition. Let us complete it once and for all.
With respect to the pending dues, Lordship, I have submitted only a 20 pages document, Lordship. Against the 20 pages document.
These pending dues are pertaining, relating to this issue.
Lordship, there are pending dues with respect to my medical benefit that they mentioned in this honorable court that they already released, but this is a false. Their document itself prove that.
Mr. What is your name? Bora. You're Mr. Bora?
Yes, Lordship.
We are trying to understand your difficulties and quickly go through the matter so that we can complete the matter, finish it off, and then decide whether any dues are payable to you or not.
Lordship, in February 2024, this honorable court ordered to do the final hearing. But when there is a continuous effort to delay the process, Lordship. That is why
you tell us when you want to do the final hearing. We'll fix a date for you. We'll go with the final hearing.
There is in previous occasion, there is a numerous occasion that date was fixed, but it was not allowed to do the hearing. That is why I submitted a very small document by having a 20 pages document to at least to release the pending dues. Lordship, they are submitting false document. Their document itself proved that they are submitting the false statement in this honor.
So, whether you are correct or they are correct, it will require a decision of the court to find out.
Yes, Lordship, this document itself, Lordship, prove that their submission, few submission will prove that their submission are totally false, Lordship, with respect to my pending dues, Lordship.
We can reject your prayer straight away, or we can consider it with the final hearing, whichever you want it. Whether these documents are correct or not is a matter of evidence. We are not here to see which document is correct or false. We will have to examine the matter and then decide whether the claims you have made before the court in respect of your dismissal, does it require any interference? This is the issue. And it is on record that you have been offered, in fact, even I recollect, this court recollects that we had offered you the assistance of a counsel, you refused to accept. So, we will presume that you are aware of the powers of the court, the extent of examination, etc. As a writ court, we are supposed to see whether the procedure prescribed is followed, whether the inquiry has been conducted as per the rigors mentioned in the rules, whether the evidence has been properly appreciated. That is all we are supposed to see.
Lordship, I understand, but this honorable court continuously, by previous order, continuously address the pending dues. Now, Lordship, when I submit a very 20 pages document, by proving that their submission are totally false.
This claim of pending dues is relatable to the main issue here.
Lordship, penalty was imposed in 2021, but my dues were pending prior to that, Lordship.
Correct. But
they earlier said that they already cleared my dues, Lordship, but now
so
they are.
we'll examine this together when we examine the whole matter and finish it off.
Kindly at least pending of the repetition, kindly at least consider my pending dues, Lordship, because they are submitting.
No, so where is your affidavit with regard to the pending dues? 18 August.
No, 18 August is his manner.
Is his. Have you filed any response
Yes,
for that?
yes. Not against 18-8 we have not filed, madam. Against the
give your response
27-6.
Tell us what documents, what dues are pending.
According to us, madam, nothing is pending, madam. Only one amount.
Bring it on record.
You have got it on recording. The affidavit starting from page 1811. 1811.
Yes.
1813 Lordship comes to para 3. But for that, my lord, Lordship will also have to consider his representation dated 6/2/25. Para 3, my lord, we have said. Answering respondent state that the petition is there, so and so, so and so, so and so. On brief by so and so. Status of the bills at page 1350. He said status, my lord, we have already intimated to him by the document at 1810. All the bills have been paid except for one.
These have been paid. It is a clear statement at 141.
No,
1814.
Their submission itself proved that they are submitting a false statement, Lordship. Kindly allow
I
me
think,
to
ma'am,
address
this is
that.
going too far, my lord.
No,
He's
no,
making
Lordship.
continuously allegations
No,
of all false.
Mr. Bora, false or truth, we want to find it. Therefore, we want to go for a final hearing. We'll hear everything. You submit whatever you want to submit. We'll look into it.
Lordship, kindly at least refer to the page number, Lordship. Kindly refer to the page number 1822 from the submission of the respondent side, Lordship, where they claim with respect to their a single pieces of document, which is totally a fake document, Lordship. It is already proved because they could not submit anything authentic. So I request this honorable court. I already submit a pair to initiate a contempt proceeding also. Lordship, kindly refer to the page number 1822. The document itself shows that 72,631 is not released, Lordship. They, based on this document, they try to claim that this 72,631 is already released. They write Lordship, page number 1810, which the Learned Council try to rely on. And that
how are these payments released?
To his bank account, madam.
Give us the proof of that. Show us that on which date you'll be having it in your ledger.
Lordship will give me some time, madam.
Give it and file it in court.
Lordship, on numerous occasions they were given, they actually try to delay the process, Lordship. That is why I actually respectfully submit.
You tell us what process we should follow to find out that their statements are incorrect as per your submissions.
Lordship, this honorable court ordered.
How do we find out? You are saying that your statement is correct, their statement is wrong.
Yes.
How will the court find out?
Lordship, His Honorable Court in other occasion asked them to submit details and particulars. Accordingly, I submit.
That's all right. They have submitted their details as per their understanding.
My submission is that kindly provide me the details of the bank statement. They failed
No.
to submit it.
So
Lordship,
we
in
are
numerous
now
occasions, they-
My lord,
directing them to.
My lord, or
You
contra, my
submit
lord.
it.
Let him also produce his bank statements, my lord.
Why are you?
I will give it, my lord.
Lordship,
You-
what is
you
the
Kindly
reason,
see,
Lordship?
lordship will kindly see.
Please take your seat.
Yes.
Lordship will kindly see.
You have stated that these are the amounts.
We'll
to be
produce it,
paid,
my lord, no difficulty.
Right?
We'll
So
produce it, no
on
difficulty.
which date you have made this payment, give a statement from your accounts department and subfile it before the court.
Yes, no difficulty.
Uh,
Separate like that.
Do that. Do that.
We'll do it.
Lordship,
How much time do you require? 10 days.
Lordship, they submit that they will going to submit a SAP document. The SAP document is not a.
What is a SAP document?
SAP document is a processing document. The bill amount is required to be credited to my account, Lordship. There is a
No,
bank
no,
required to
you
be
are
bank statement.
making bank transfers, aren't you? So from the bank, you get a statement that these amounts on which
The
date.
bank, my lord, it will be very difficult because there will be numerous hundreds of transactions, my lord. Because it is not that only amount will be paid to him, my lord. There will be contractors' bills, there will be salaries, accounts of others, my lord.
Mr. Counsel,
My lord.
we are living in the age of AI.
Yes, definitely.
So don't tell us that it is difficult for a bank authority
No,
to
we
find
can-
out.
We can produce,
what
we can
payment has
produce
been
these
done.
statements, my lord. We can produce these statements.
We
but
don't want the statements. We want the statements with the amounts released to him marked.
Particularly,
That's all.
let us try. my lord.
It's not for you to do it. You ask the bank officers to do it. They'll do it for you.
He may not, my lord. Ultimately, we'll have to work it out because it is ultimately payment is released from us. I will try to find out, my lord.
Payment is released from your account to his account.
Yes, we'll try to find out, my lord.
Lords, there
Your
are
lordship, for a moment, my lord, 1810, in 1810, the first amount is 14014. That is corresponding to 1817, my lord. Now, 1810, the first figure of 14014.
The affidavit starts at 1811.
No, my lord, his affidavit, last page.
His affidavit.
His affidavit, last page.
Actually, this document is submitted by them only.
No, his affidavit begins at
1797.
1837.
No, this is his affidavit of 188. The earlier affidavit. Starting at 1797.
1797. No, it is not here. It's here somewhere, but we are unable to.
May I
look
just
at it.
hand over the page, ma'am?
Let us side copy. There are two files. Okay? Yes.
Lordship sees the first figure 14014. That is corresponding to page 1817, madam. Similarly, 51821. That is 1818. Then
No, but
3088.
these are things you have shown that you have paid it.
Yes, these are the payment
So
volume.
you give the
All right,
details
all right.
corresponding to this. That's the end of it.
Claim 14.
That's what you want, isn't it?
I never claim against 14014. Why they submitted this?
My lord, he might have claimed 24,000 or 50,000, my lord. What is admissible, that has only been paid. Now, if he is disputing that, my lord, he'll have to file a writ petition.
Lordship, there is no need to submit a writ petition. Because in a writ petition, I specifically mention my claim, Lordship. I specifically mention against my submission, they repeatedly for last.
Have you received these amounts at 1810?
1810.
Page
1810.
Oh, 10. Lordship, with respect to the details given, form serial number 567, I did not receive this. Their document itself proved that they did not release those amounts.
567.
Lordship, their document.
So 1, 2, 3, 4 you have received.
I never claim it, Lordship. Why?
1, 2, 3, 4.
Yes, I already received, Lordship.
You received.
I never actually claim 1, 2, 3, 4, Lordship.
All right, whatever it may be, received.
Regarding 5, 6, 7, and 8, their document.
8 has not been paid yet, man.
But last 2 years they submit to this honorable court. There is no any pending dues, Lordship. Though this honorable court repeatedly in numerous occasions ordered them to examine my claim, Lordship.
All right, 5, 6, 7, you give the details.
All right.
Bank statement. But where is the question of what about 8? Is not received due to suspension.
This is due to suspension.
What is this amount?
That 19,336.
And what is the finding of the disciplinary authority regarding the period of suspension?
That I have to find out.
There is none.
No, the period of suspension, he did not even join, even prior day to my lord.
What is the finding?
I'll come. There is no finding.
Then what will
No,
happen?
this is the medical reimbursement.
No. Salary slip was not generated due to suspension. We
Or
don't
it was not generated.
know.
That is why this medical reimbursement could not be paid.
Okay. Now pursuant.
No, we'll
to
be
the
paying it, my lord.
Huh?
To be released. Lordship will look at it to be released.
No, to be released, but whether it is released or not.
It is not released as per my instruction. It is
So
not.
why release it? Why?
We'll release it, my lord. We'll
Why
release
has it not been released?
We'll release it, my lord.
No. You release it and give us all the statement
Yes.
to the payments. 1, 2, 3, 4, there's no dispute, you have received it.
Yes, Lordship.
So 5, 6, 7, 8, you have not received.
Yes, Lordship.
So you give
Lordship,
the details.
There is another claim, Lordship, that they for the first time hide their affidavit, recent affidavit. They after 2 years they acknowledge that they do not have those documents. But earlier they mentioned that.
We'll see. When do you want it? Mr. Dega, when can you give it?
Last week before the vacations, maybe if possible, my lord.
Lordship, may I submit a kind and respectful submission? Lordship, I have recently submitted 20 pages affidavit only based upon my pending dues, Lordship. This document, Lordship.
When did you file it?
Lordship, I filed it on 18th of.
We have it. We have it.
Yeah, Lordship,
Yes.
if I get the details and particular against each paragraph, Lordship, then I will get all the details that.
See, Mr. Bora, coming to court is a right, but getting a hearing may not be always. You see, we are trying to sort out your issue of termination. You are running after the dues which you are supposed to get, not get. This will be determined once we come to a conclusion whether your termination was done as per procedure followed or not. That will require some time. Allow us to proceed in the hearing. Once we go ahead, we decide. And if we come to a conclusion that your removal or termination was unauthorized, contrary to law, you are entitled to be reinstated and get all the dues.
Yes, Lordship.
Including these dues which you have filed in this affidavit.
Lordship, I acknowledge
You
it,
have
Lordship.
come before the court not asking for the dues. You have come before the court challenging your termination.
Yes, Lordship, I acknowledge it, Lordship. I submitted this petition on 2023 March, Lordship. From March 2023 to 2020.
This is not your case alone.
Lordship,
You check the list, there are 2013-14 matters pending. In spite of the court trying to
Lordship,
get the hearing done, the matters are being sought to be adjourned.
Yes, Lordship, I'm trying to address to this honorable why I raised the pending dues, Lordship. Though in my writ petition, I already submitted a pair with respect to my pending dues. But I totally actually Lordship did not address this issue from 2024 February to
Which is why
2025 January, because there is a
repeatedly the court had given you the option of appointing an experienced counsel so that your case can be carried effortlessly through the maze of these documents.
Lordship,
But you are refusing to accept that.
Lordship, the last one from 2024 to 2025, I did not raise this raise about my pending dues because there is a order for final hearing. But
All right,
since there is
this matter again on 22nd, Mr. Decca will furnish necessary particulars showing the bank transfers from the NRL to the petitioner in respect of the payments which are reflected in the in Annexure 9B. What is this Annexure 9B?
9B.
Annexure 9B to the affidavit filed by the petitioner in person
no, not 9B, sir.
on
This is not-
27/6/2025.
Lordship, my submission was Annexure 9A, Lordship. It is their submission, Lordship, 9B. My claim is 9A, Lordship.
What is 9A? Is this Annexure 9B?
9B was a document which I had handed over to him during the
No.
course of the hearing. This is an internal communication by which the status of these payments, whatever is admissible has been paid.
Your 9A, you have referred to medical bills at pages 1350 to 1359. Where are these?
It is in the repression, Lordship.
Where is it? Show us.
350.
One three five zero. Yeah, here's my contract. One three five zero to 1359. Hmm. 1350. What is 135? Oh, this is 19. 19 this year. One three five zero. What is 1350?
These are the form 1350, 1351. These are the actually medical bills that I submitted. Again, this with the form.
This appears to be
Everything is clean.
1351. It doesn't appear to be medical bills.
Is it
1350 is medical.
medical bill?
Huh?
Claims, not bills. They are claim forms.
এটা particular serially রাখি দিব after it is your claims in medical bill may not be entirely accepted by them, then maybe rejected by them also.
They did not reject, Lordship. They already processed it, Lordship.
Hmm.
They already submitted some document which clearly shows that they processed it, but they did not release it, Lordship. The amount they did not release it, Lordship. They hold it without submitting any reason, Lordship.
1350. কি লিখলেন? As also the medical bills claimed by the petitioner, which are stated to have been processed but not released, details of which are reflected in the representation dated 6/2/2025, Annexure 9 capital A, the affidavit dated 27/6/2025. Stop.
No.
Let this information be placed before the court with supporting. Are you filing an affidavit or?
We'll file an affidavit if need
Right,
be.
be brought on record with all necessary documents by filing an affidavit on 22nd.
Lordship will make an attempt, my lord. If something is there, Lordship will accommodate me, my lord.
So, last 2 years, Lordship, there is a continuously, there is a, for similar issue, Lordship, there is a continuous request.
22nd September. 22nd
So there
September.
is some mistake in the paginations.
We don't know. Whatever.
We're not telling with ours, my lord.
There are medical bills as well as the gratuity amount as well as leave encashment.
Excellent.
They actually though released it, they did not give any details of it.
Have you mentioned in this
Yes.
9A?
Lord.
Is it mentioned in 9A?
9A was submitted prior to release those amount, Lordship. In my recent submission, I give all the details, Lordship. Recent submission by affidavit dated 18/08/2025.
Where are the details?
From serial number, Lordship, 7, from page number 1840, Lordship.
But you have to quantify that amount. Where is that amount? You bring it by the next date, let us see. Let them first come, give the information regarding these bills at 9A.
9B, my lord.
9B as well as 9A.
9A.
You have made a.
No, 9B is corresponding.
9A.
9B is corresponding to 9A.
In 9A, as per 9A document, they required to submit the details of my amount that they were released. Also. They claim that they released gratuity amount that they did not give me the details. Also.
That is what we are asking.
Yes, Lordship.
That is what we are asking. List again on 22nd.
Kindly mention that this is a final opportunity given, but otherwise they were always.
Not necessary.